Hi, everyone. Welcome in. Thanks for joining us. My name is Carrie. Oh, and spoiler alert, today's topic, the Darrell Brooks trial. Now, I say this because I've had a few people, just a few, not many, because most of you guys get it, but just a few people in the comments will put, why are you still spotlighting this trial? And I just shake my head and I think they probably just weren't into it at the time, or I don't know, they just didn't get it. Everybody has their own preferences, right? But those of us that do get it apparently can't get enough of it. So I put together something for you all, my take on the trial in 5-minute segments. So here's part 1. Enjoy.
Mr. Brooks, stop talking.
Objection, hearsay.
You would like to, you're asking that to voluntarily be taken to that courtroom.
All right, why don't we print that off so that Mr. Brooks can review that as well.
Into being called that name, and what do I need to be reviewing?
Can I come back? Can I come back? Can I come back?
I will take these in order. The first is a note from Mr. Brooks that was handed to Deputy Wittig at about 12:05. It says, I would like my filings addressed, parenthesis, notice of special appearance, statement of particulars, both are by affidavit, filed 10/3/22, which today is deadline to respond. Thank you, Mr. Brooks. I'm respectfully declining to respond to those filings.
With all due respect.
I'm going to mute him.
Still need to address subject matter jurisdiction before the jury's brought out.
I will not be doing that.
Will it be proven for the record? Why you should put it up in here? Don't even tell the jury the truth.
Remove me then.
I have to rule on the request, sir. It's been a proposal filed with the court.
You haven't ruled on subject matter jurisdiction yet.
Yes, I have.
No, you keep changing the jurisdiction. Jurisdiction is a subject matter jurisdiction that has yet to be proven on the record. So is that a tacit agreement that you don't have to answer that question, Your Honor?
I make no such agreements with you, sir.
I'm seeking to merely understand.
Sir, I cannot give you legal advice. I cannot give you the understanding that you want.
And I object to that. I've yet to prove subject matter jurisdiction.
But, Mr. Brooks, you're being taken to the next
Mr.
courtroom.
Brooks. Don't try to address me
Thank
like
you.
that, like we cool. You don't have no integrity. How can you even call yourself a judge? Making tacit agreements, being biased, judicial misconduct, trying to steal somebody's system.
One last time, Mr. Brooks, do you have a position on
Can
the
I
state's
go over the
proposed-
document, please? Can I do that, Your Honor? Respectfully
sorry?
for the record, may I do that? Can I at least raise the issue of subject matter jurisdiction? That's
No, there's no lawful motion before the court. You may not.
a reference to the charges in this matter. Paperwork that would state the charges. Any paperwork.
I just want to be treated fairly, which I
Please?
have not been.
So can we adjust the subject matter jurisdiction?
No, we cannot.
Talk about that.
Your Honor, as a
Mr.
public
Brooks.
servant, I have the right to ask questions
Sir?
of Your Honor.
Are you aware of who the plaintiff is in this matter?
Objection relevance.
Grounds.
We're talking about constitutional rights.
Are you aware that the state of Wisconsin is an entity and cannot claim to be an injured party in this matter?
Objection.
Grounds.
906-11.
So what is the purpose of me being present if I'm not able to ask simple questions that I do not understand? Objection. Hearsay.
It's not hearsay.
That's my decision, sir. Next
Are you
topic.
making a judicial determination that those have no merit?
Mr. Brooks, I have indicated to you on the record what I will or will not do.
I would like to motion for a finding of fact.
Your request is denied.
Objection. What was the answer to the last question?
So this is your final warning, or you will be removed to the other courtroom.
Objection. Leading the witness.
He's muted. The record should reflect. It appears he's talking as well. He's making hand gestures. His lips are moving behind the mask.
In any event, do you have a position on the jury view, sir?
Yeah, what about subject matter jurisdiction? Man, I ain't trying to hear all that because at the end of the day, I did what you asked me to do. I'm simply trying to have a fair trial. Will Your Honor honor my First Amendment right?
I'm not
Are you
answering
making
that
it- or are
question,
you
sir,
making
because
it-
I've already addressed
So
it.
you're making a judicial determination to deprive me of my constitutional
I am not
right.
making any such determination,
So
sir.
you just said you're not going to answer the question about my First Amendment right, which says
Sir,
that
I've
I have
already
freedom of
answered the
speech.
question that you have a right to present a defense.
That is the
You have
Sixth
a right
Amendment,
to
not
be
the First.
present.
You're trying to twist
You
up the
have
amendments.
a right to present your defense, but your rights are not unfettered.
Objection. Hearsay.
Overruled. The record will reflect that Mr. Brooks did not give consent.
Mr. Brooks, new topic, or under 90611, I will close the cross-examination.
And we're back for another day here with the Darrell Brooks trial. The trial that never ends, the trial that we can't seem to get enough of. And why can we not get enough of it? Well, this is why.
And just for the record, Mr. Brooks is appearing from the other courtroom. That should not influence your verdict in any way, ladies and gentlemen of the jury.
I'm seeking really to understand, Your Honor. I don't understand the nature and cause of the charges.
Mr. Brooks, I've already dealt with these.
I can't even
So-
get these admitted into evidence. For the record,
All right.
I didn't bring up the word
Let us
violated.
continue then. We're going to move on, Mr. Brooks. Let us
So-
continue with the
So we
questioning
gonna move on
of...
to subject matter jurisdiction that
No,
has
I'm
yet
not.
to be proven?
Detective Carpenter, you can please come on back up to the witness stand, and Madam Clerk, you can have the jurors brought out.
So we're not gonna address that at all? That's not gonna be proven for the record? Is that a judicial determination that you don't have to answer the question, Your Honor? Is that also a tactic agreement?
Continue to interrupt. You risk forfeiting your right to be present in this courtroom.
Your Honor, may I see a sworn affidavit of the nature and authority of the court? Grounds. I hope the record reflects that.
Do you have any objection to Exhibit 82?
Yeah, I got objection.
What's the objection, sir?
What is the relevancy of Exhibit 82?
82 is your interview with Detective Carpenter and Detective Stern.
I will not have you claim legitimacy for what are debunked, frivolous, sovereign arguments.
Are you aware of who the plaintiff is in this matter?
Objection, relevance.
Grounds. We're not going to address that either. That's still not going to be proven, right?
And did you notice anything different about your surroundings as you heard the screaming?
Objection. I asked the form of that question and it was answered.
Overruled, he may answer.
Can you just repeat the question, please?
Sure. Did you notice anything other than the screaming that seemed unusual when that happened?
Objection, different question.
Overruled. I'm not sure what the objection is, but you may answer.
Can you just repeat the question, please?
That's Mr. Brooks. I cannot explain to you if you don't understand the basis in law for the denial.
You're right. I don't understand.
I know you're holding up your objection sign, sir, but I am giving you the opportunity to come back over here. Would you like to come back to this courtroom?
I see the whole strategy here by the prosecution. I see right through it. Don't have any cross-examination, mainly because you've already schooled the people getting on the stand on how to answer certain things.
Record should reflect he's holding up his objection sign. It appears that he's writing I don't know what, of course. Mr. Brooks, I'm going to ask you again. Would you like to come back to this courtroom for opening statements? That's not how it was said.
That was how I said. You want to run the record back?
And you're
Nice try.
see-through.
But I see through it.
So,
With all due respect, Your Honor,
Mr. Brooks, by saying all due respect doesn't change the fact that you're interrupting me. Your objection is noted.
And again, I believe you're questioning him about legal issues that aren't relevant, but you're the proponent, you want to question him, what's the legal basis you believe I should allow you to continue with that?
What legal basis are you referring to?
Can the Title IX please direct the prosecutor to answer whether there are assessment for the charges
Mr. Brooks.
in her possession?
No one's going to be answering these questions, okay?
Will we be addressing subject matter jurisdiction on the record, and will it be verified and proven?
I'm tired of being in the courtroom that has no integrity whatsoever.
Your Honor, that's the playing field that you willingly entered into and made a deliberate decision to waive your right to an attorney and to appear in this case as your own attorney.
To represent myself pro per. At that time, were you provided the complaint in this issue?
Your Honor, I do not agree to it.
The record to reflect. Reason for bringing it up was to make sure that they are offered into evidence.
Sir, we're not at the evidentiary phase. They're part of the record. They've been received. So I'm not hearing a request from you at this time. You said you wanted to raise a legal issue. What's the legal issue?
The legal issue is how is the state allowed to coach the
You're
people
assuming they spoke to them and coached them.
It's obvious. I'm not stupid.
Well, I disagree with that, sir.
I don't consent to this. First of all, I accept for value in return for value this paperwork. Don't I have rights though, Your Honor? I don't understand anything, and I accept for value in return for value this document.
Information and all documents in this case. Your objection is noted. It does not need to be repeated. Thank you. Mr. Brooks.
I have a right to be present for trial. Are you aware that I don't identify by that name?
Welcome, everyone. My name is Carrie, and it is Friday, and it's time for another edition of a Scrappy-Doo Brooks court compilation. We hope you are ready. We thank you for joining us. Sometimes he's so irritating, it's funny. Sometimes he's so dumb, it's funny. Most of the time, though, he's just irritating.
I don't understand the jury instructions. I don't understand anything that's in these proceedings, and I'm not going to participate in something that I don't understand.
Provided you yesterday as a courtesy with a copy of my oaths of office. My name is on that as well.
They were not certified.
You are attempting to disrupt with asking questions like this.
I'm here concerning this matter as third-party intervener.
I don't know if the mics are on.
It should be. Yes.
Okay. I'm soft-spoken, I'm sorry.
Said no one ever.
Oh,
that was all loud, sorry.
So
Nobody reported on record about me being bruised up and having to get bandaged up. Was not. And I would like the record to reflect that you have not shown verified proof of subject matter jurisdiction whatsoever. And that by refusing to answer, that is a tacit agreement by you, Your Honor, which you understand what that means. I know you do. Can I go back in the other courtroom? Because I'm not going to do this with you. I'm not.
You interrupt. You don't wait for anyone to finish.
I don't consent to being called by the name that this court chooses to identify me by. I want to state for the record that I'm here as a third-party intervener on special appearance on behalf of my client. Can that be noted for the record?
It was noted this morning.
May it be noted again for the record so that we can keep the record clear and accurate.
I'll make a finding that he's forfeiting his right to be present in this
I didn't forfeit
courtroom.
anything. I asked.
The court will let the jury know that when they come
So
in.
are
Yes.
you overruling the fact that the true nature and cause has not been presented to me? That I don't know what the true nature and cause of the charges are? Grounds for the sustain, Your Honor.
Next question.
So I can't get no grounds. Okay. I'm not making a voluntary waivery of anything.
So there'd been the subpoena sheet that would have had your name and a number of different.
What do you mean my name? What are you referring to?
I believe it would have said Darrell Brooks on it.
Are you aware that I don't identify by that name?
Objection, argument.
Sustained.
Sorry.
Are you willing to expressly waive that right on the record right now?
I'm not going to expressively waive anything. I'm seeking to merely understand.
Sir, I cannot give you legal advice. I cannot give you the understanding that you want.
I need to make an
I
appropriate record.
just told you that I don't understand the questions you're asking. What do you want me to do? You seem like the same thing that was there yesterday.
It's not. There are some changes.
What changes?
Reference
It's
to
the same.
the-
It's the same document. That was
Reference to
accepted for value,
the-
returned for value yesterday. The same document. Now, please go back into the other courtroom. Not allowed to.
Not now. The jury is in this courtroom and you will show respect for them and for this court. Sorry, was there an objection
Yes.
on the basis of the objection?
Relevancy.
It is relevant. It is received, 51B.
Objection be noted for the record, Your Honor.
It already has been.
I can't answer something I don't understand.
I believe you're choosing not to answer them,
You can
sir.
believe what you want to believe. I believe that you hiding stuff from the jury. I believe you haven't been impartial or fair. You haven't let me even enter anything into evidence, which is my right to do so. I want to
Stop interrupting me.
You were quiet. I didn't.
Mr. Brooks,
Respect for them would be
Mr. Brooks,
telling them the truth.
stop. All right. Bring the jury in, Madam Clerk.
And I object to that.
To the timing?
Yes. It is my right to do so or to not do so.
If I have you stay in this courtroom, are you willing to follow the rules of decorum and courtesy?
I do not understand the question you are asking. It is frivolous, though. That's gonna get pressed every time. So I have yet to prove subject matter jurisdiction, any jurisdiction at all, rather.
The jury will disregard the comments being made by Mr. Brooks at this time. They are a mischaracterization of the law.
Absolutely not. They are absolutely not. I don't understand.
all right? You willingly waived your right to an attorney. I made all of those findings, so we will go
You
forward.
made those findings,
I
but
am
they-
not obligated to answer questions.
made
When you
those
ask me
filings.
questions, I'm going to mute him.
Hi, everyone. Welcome in. My name's Carrie, and this is a pre-recorded premiere of Mr. Darrell Brooks, the Waukesha Parade attacker, who decides to call up some of his own witnesses that did not help him at all. In fact, most of them hurt him. And I've put together a little compilation here of their responses to his repetitive questions. And I've even added some bonus at the end of how the prosecution gets up and just slams that door on it all. And the beauty of it is if you watched on one of my first videos that I ever posted about this trial, I trimmed it as much as I possibly could, but I wanted to show everybody all the steps that the judge went through to make sure that this guy understood that if he acted as his own defense, what he was up against, what it meant, where he'd be in all of this. And she went through every single thing with him. And he still wanted to come back and say that she didn't tell him everything, but it doesn't matter. She did. He's now defending himself. He doesn't know. He doesn't have a clue. He does not have a clue what he's doing. And with that, let's get to the video.
The defense may call its next witness.
Who's here?
Bertram, Hayes, Aldrich, and Lescano are present and ready, Your Honor.
Thank you.
What was the last two?
Aldrich and Lescano.
What did you see?
Besides the parade?
Yeah, I'm sorry. That was unusual. They caught your eye that evening.
Well, where we were, yes, a red truck came through where we were. It honked and swerved.
Do you recall telling her there's a shooting?
Possibly.
I'm assuming at some point your attention got drawn to something happening. That be fair to say?
Not necessarily.
You just used the name Mr. Brooks for the first time since you've been testifying. Is that fair to say?
That's fair to say, yes.
Why haven't you used that name before? You've been up there for quite some time.
I didn't need to.
Your Honor, I object. Well, I realize there's no question at this point, but if he's going to ask the witness to answer his prior question, now that he's clarified, this is irrelevant questioning.
Do you recall?
I just answered that.
Did you observe at any time that evening seeing someone run from the vehicle?
No.
Do you recall stating that the other two were described as running in a westerly direction from the rear of 338 Maple Street?
No.
What were you doing that evening?
Went to the parade?
It was relevant. He said what was on his
No,
subpoena.
you've talked at length about the subpoena, so under 90611, move on to a new topic, please.
So what changed for the last question that you needed to?
I don't understand your question.
And what did you see that day, if you recall?
I saw a red SUV plow over a bunch of people.
Did you get a description of who was driving the vehicle you saw that day?
I did not.
Did you get a license plate?
I did not.
Do you recall if the vehicle had any tinted windows?
No.
Do you recall who served you the subpoena?
Objection relevant.
Grounds.
Overruled, the witness may answer.
The district attorney's office from Waukesha.
Do you recall if it was a specific district attorney?
I do not recall.
Did you see anyone else in the vehicle?
No.
And do you recall being informed that it was a possibility that you would be testifying in this matter?
No, I did not know that.
If he would like to call the DCI agent, then he may do so.
Grounds. Do you recall the gist of what you prepared?
Can you be more specific?
So why not be very confident the first time the question was asked? Grounds. Grounds. And Did you see the driver of this SUV you're referring to?
Yeah, you're standing right there.
That question wasn't answered, but okay. So what other details do you not recall?
Objection. Your Honor, how does someone recall the details that they don't recall?
Yeah, that's what I wonder.
Sustained is to the form of the question.
Seems very funny. Do you recall if the vehicle passed close to where you were walking at the time?
Yeah, it was close enough that it could have easily have had clipped me or the two people that were in front of me.
But you do recall seeing the operator wearing a black sweater?
I don't remember.
And how many people did you see in the vehicle?
Just one, the driver.
So, do you recall flagging down a law enforcement vehicle that evening?
Yeah, I do.
And do you recall what you told the officer that evening?
Not very well.
You just stated that you didn't mention the name before because you didn't need to. So what about the last question that you answered made you feel like you needed to use the name for that question and no question before that?
I don't know.
The evening of November 21st, 2021. You recall that evening pretty well?
Fairly well, yes.
Do you recall why you would have gave a description that evening when initially interviewed by law enforcement?
Because I saw the person in the car.
And how did that person look?
I don't remember.
Grounds?
Well, this answer may stand.
That you observed 3 or 4 people in the SUV as it passed you?
I don't remember that.
Honked and swerved?
Yes.
What did it swerve from?
I'm sorry?
What did it swerve from?
Where?
The one that you received from the district attorney's office in July didn't have a case caption on it?
Okay, what's a case caption?
So, to your recollection, the SUV that you saw, did it have tinted windows?
I don't remember.
So, well, before we get to that, did you see where the vehicle went after it honked and swerved?
Yes, it kept on going straight down Main, east, well, the same route the parade went.
Sir, in July when you received your subpoena from the district attorney's office, were you even aware what you were being subpoenaed for?
Objection, relevance.
Grounds?
Sustained. Not relevant.
She's testifying in the trial and it's not relevant that she got subpoenaed?
Mr. Brooks, she's here under your subpoena.
And do you remember what the description was that evening that you gave to law enforcement?
I told him it was a red SUV.
The description of the driver, do you remember that?
I know he was a black male.
Did you happen to catch the license plate number of the vehicle at that time?
No, not at all.
And did you see the vehicle stop on Maple Street?
Which vehicle?
The SUV that you claim you saw.
Oh, no, I didn't see it stop, no. It kept going through the parade.
And I'm assuming at some point you either were interviewed by law enforcement or seek to be interviewed by law enforcement.
I did, by a detective.
And did you know who the trial was for?
Objection.
Grounds.
Sustained.
Grounds for the sustained.
It's not
I've
relevant.
never heard of nobody testifying in a trial that they didn't know who the trial was for.
Under 90611, please ask a question, sir.
Man, what is y'all people trying to pull up, man? This is. Do you recall having a conversation with the plaintiff?
Objection.
Grounds.
Misleading, legally inaccurate statement. Your Honor.
Grounds.
Sustained as to the form of the question.
Which of these subjects do you minimally recall wearing those items that evening?
No, you asked me if I remember people running, and I said no. I remember describing those people to him.
Or was it, I guess the correct question would be, why did it swerve?
I don't know. I wasn't driving. I don't know what his intentions were.
Objection.
Grounds.
Okay, so first of all, the
Grounds.
grounds are relevancy. It's not relevant. That would be the
You
grounds.
also have to state the grounds.
Hold on, let her get her position out, Mr. Brooks.
And it mischaracterizes the former testimony.
It does
Sustained as to both grounds.
Your Honor, with all due respect, that's every question that I'm asking is relevant. It pertains to the plaintiff in this matter that seems to be nowhere found.
Making a legal argument, we'll take that up outside the presence of the jury. Move on.
I believe the jury deserves to know who the plaintiff is in this matter. That's very relevant to the case. How can they rule on something when they don't
Mr.
even know
Brooks,
who the plaintiff is?
please, move on.
And do you recall about how long ago you received that subpoena?
Several weeks ago.
So pretty recent, would be fair to say.
Yes, I would. Well, several weeks ago. I'm not sure if that's your definition of recent or not.
Ask a question, or I will declare the examination by you to be ended.
It's not an examination. It's direct.
It's a direct examination, sir.
Just so we have clarity, describe the subjects you saw that evening standing by the vehicle.
I don't remember that good.
Can you rephrase the question? I'm not understanding.
I think it was clear, but I'll ask again. Do you recall having a phone conversation with the plaintiff in these
Same objection.
grounds?
Sustained as to the form of the question.
Do you yourself recall reaching out to the plaintiff in this matter?
I mean, you were describing them, so it brought back a little bit, but I can't tell you. That was too long ago.
Do you recall stating that it honked several times?
I don't recall.
When you were initially...
I don't recall.
You're recalling what you want to recall and purposely not recalling.
Objection.
Don't.
Badgering the witness.
Yes, sustained. You do not have to answer that, and you are warned. You may not badger or argue with this witness. Next question.
Do you recall stating that you saw the SUV reverse into a driveway?
No.
Do you recall why that would be reported?
No.
What does that consist of? What are their resources in pursuant to the complaint that you filed or claim that you filed, right?
Can you rephrase?
Do you recall why the report says that you advised Detective Moss that there are 3 black subjects, specifically black subjects, running from the vehicle?
No, I don't remember.
Please ask your question again so that I'm clear.
Have you yourself ever reached out to the plaintiff in this matter?
And my objection is it's vague and it's legally inaccurate.
Sustained as to the form of the question.
So it'd be fair to say that you spoke with 2 different law enforcement officers that evening? Do you even know if there's a plaintiff in this matter?
Objection
Grounds?
argumentative.
Sustained as to the form of the question.
Do you recall in your interview with Detective Coates, in reference to the vehicle that you saw that evening, do you recall telling Detective Coates that it appeared there were 3 or 4 people in the Ford Escape as it passed you?
No, I don't remember that.
No further questions?
Any redirect?
No, Your Honor, I'd ask Mr. Schloman be excused.
All right, thank you, sir. You may step down. And he is excused.
State will call Robert Stone.
Do you recall in your interview with Detective Coates that evening stating that you could not provide any description of the occupants other than that they appeared to be African American?
Yeah, I remember saying that.
So it'd be fair to say that you observed African Americans in this vehicle that you saw, correct?
The reason why I came up with 3 or 4 people was because when I was walking by and I saw the car, there was 2 or 3 black males standing by the vehicle, and there was at least 3 or 4 more on the porch. So I figured they were by the vehicle. It must have been the ones trying to hide the vehicle because they were standing in front of it or real close to it.
In your opinion, did it look like they were nervous or attempting to hide?
Well, everybody was running past them and walking really fast, and they were just standing around there.
While at the parade that evening, do you recall stating to Detective Coates that it appeared that there were 3 or 4 people in the Ford Escape as it passed you during the parade that evening?
No, I don't remember that. I saw the driver going by because he hit somebody right in front of us.
And during that interview with Detective Coates that evening, do you recall stating to Detective Coates that you may be able to recognize the older male? So I'm assuming one of the individuals that you saw standing shoulder to shoulder was a older male?
Yeah, I don't remember.
Any reason why I'm not gonna say multiple, 2. Any reason why the 2 detectives that you spoke with that night both reported that you stated you saw 3 black subjects running from the vehicle?
No.
No further questions at this time.
Thank you. Any cross?
Yes, Your Honor, thank you. Good afternoon, Mr. Lascano.
Good afternoon.
Sir, you said you watched the parade near Curry Insurance, is that correct?
Yeah, right in front.
Okay. Do you remember, you said you saw the SUV strike some people in the parade?
Yeah.
Yes? Do you remember what group of people in the parade? Can you remember anything about the name or the banner or the costumes or anything like that?
Objection, leading.
Overruled. Ms. Cross.
No, speculative. Objection.
Overruled. The witness may answer. I believe he said no. His answer may
Yeah, no, I don't remember.
Okay. Do you remember seeing the SUV strike more than one person?
Yeah.
Objection, speculative.
Overruled.
About how many people did you see the SUV strike, sir?
Objection speculative.
It was crowds. I mean, when it was coming through, because I was standing over my daughter and my wife, they were sitting on the curb. I saw it coming through, and at first it looked like it was just pushing people out of the way, and then it just kept swerving back, and it was just plowing everybody out of the way until it got to in front of us. Then it actually hit somebody, and it just did like a cartwheel in the air.
You remember that?
Yeah, it was right in front of us.
Okay. So, Mr. Liscano, I want to talk about the moment when you located this vehicle on Maple, okay? I'm going to ask, Madam Clerk, could you please turn on the AV system? We're going to put up State's Exhibit 65. Go ahead.
Objection to the relevancy of Exhibit 65.
Noted, overruled. It's been received. The state may proceed.
All right. This total clip is 36 seconds, but before we begin to play it, sir, do you recognize the area on the screen that's shown in this picture?
Yeah, I believe that's Central Middle School.
Where?
Right at where the stairs is.
Okay, the red brick on the left side of the picture?
Yeah.
Objection
Okay.
speculative.
Overruled. His answer may stand, he said, I believe.
And would you agree with me the house where the SUV was found was up in this area here where I just put the green dot on the screen?
Yeah.
Objection leading.
Overruled. You may answer.
Yes.
That looks right, correct, sir?
Objection leading.
Overruled.
All right, we're gonna clear the screen, please, and we're gonna play this entire clip for 36 seconds. Please watch and see if you see yourself or any of your family members in this clip.
Objection to the relevancy of this video to this particular witness.
Overruled. You may play the clip.
Overruled on what grounds, Your Honor? Is that attacking agreement?
Sir, did you see yourself or your family in that clip?
Objection speculative.
Overruled.
No, I did not.
Okay. Now you said you did see, by the time you walked past the car, you saw 2 or 3 black males standing near the car, right?
Objection mischaracterization of this. He said 3. Specifically said the number.
Overruled.
And you also said you saw 2 or 3 what you thought to be black males on the porch of the residence there, correct?
Objection. He stated it was black males. Asked and answered.
Overruled. The witness may answer.
No.
I'm sorry, go ahead.
No, there was 2 or 3 standing by the vehicle.
Okay.
And then on the porch, there was maybe 3 or 4 or more people. I don't know if they were, I'm sure they were white, but
okay.
I was trying to not make it obvious because at the time, I believe that they were with the vehicle, so I didn't want them to see that I saw them, so I just did what I thought was right at the time.
Sure. Do you happen to know the people that live at this house?
Objection speculative.
Overruled.
No, I do not.
Would it be reasonable, do you think, Mr. Lescano, that people living in the house heard the crash and came outside and that's who you saw standing there by the vehicle?
Objection. There was never any crash mentioned.
I'll sustain. It calls for speculation.
Mr. Lescano, is it possible that the people you saw standing near the vehicle were in fact just neighbors that saw the vehicle the same way you did?
Yeah.
You described that at the time you went by on Maple Street, there was a lot of people running around in the area. Is that correct?
Objection, mischaracterization of testimony.
Overruled.
Yes, there was.
And these are people hurrying away from the parade with their families, trying to get to safety just like you were, correct?
Objection, speculative.
Overruled. The witness may answer.
Yes.
You didn't see anything like that in State's Exhibit 65, did you?
No, I did not.
Okay. You said on direct examination that you saw the driver of the SUV in the parade. Is that right?
Yes, I did.
And you see that driver present in this courtroom here today, please?
Objection speculative.
Overruled.
Yes, he's sitting right over there.
Are you sure about that, sir?
Yes.
Objection speculative.
Overruled.
You said
And
that...
this mischaracterizes the testimony because that was not testified to before on direct.
Oh, your objections are overruled. I believe the witness already answered. Go ahead.
Did you happen to notice in Exhibit 65 the red SUV in that video clip that you watched?
No.
You didn't see it at
Couldn't
all,
see
did
it,
you?
no.
Okay, just wondered. Mr. Liscano, have you and I ever spoken about this case, sir?
No.
What about Attorney Basie here to my right? You and her ever talk about this case or your testimony?
Objection hearsay.
Overruled.
No.
Mr. Witchow on the end, did you ever talk to him about
Objection.
your testimony, sir?
Objection hearsay.
Overruled.
No.
All right, thank you, sir. I don't have any other questions.
Thank you. Any redirect?
Yep.
Go ahead.
You stated that you saw the driver, correct? Of the SUV that you saw that day, correct?
Yes.
And how did the driver look that day you saw him?
He had a scruffy beard and he was a black male.
Did you see what the driver was wearing?
No, I don't remember that.
Did you see if the driver had any hair?
I don't remember that either.
Did you see if the driver had anything noticeable about their appearance? Tattoos, scars, marks, anything like that?
No. I saw the side, the profile, the side. You were flying fast down that street. I wasn't paying attention to the colored clothes you were wearing. I knew it was a black male and had a scruffy beard. It's the first thing I told my wife, is he was a black guy driving.
And do you recall how long you were able to get a side view, as you called it, of the alleged driver?
Well, it had to be a couple seconds.
And in a couple seconds time, you were able to make out the driver's profile and race just by a couple seconds.
Yeah. It's not hard. You can tell if you were white or if you were black and if you had a beard or not. That's it. I don't know what color shirt you had on. If you had hair, a hat on backwards.
So that leads back to the question of, is that the only person you saw in the vehicle?
From what I remember, yes. I saw the driver. Like I said before, the reason why I thought there was 3 or 4 because I saw 3 or 4 people around the vehicle when I spotted it.
So would it be
That's the only reason.
Would it be fair to say that when you spoke with 2 different detectives that evening, the evening of the parade, both of those officers reported that you stated there were 3 or 4 people in the SUV as it passed you? Is that fair to say?
Oh, wait, can you repeat that again?
Just for clarification, you already stated previously in testimony that you spoke with 2 different detectives that evening, correct?
Yes, I did.
And both detectives that you spoke with that evening, the evening of November 21st, 2021, you stated to both of those law enforcement officers, detectives, that you observed 3 or 4 people in the SUV.
Like I said before, the reason why I said there must have been 3 or 4 was because they were standing by a vehicle. So I assumed that they were with the vehicle. I don't remember seeing them in the vehicle when you were hitting the people.
You stated this to both detectives, 2 different detectives, the evening of November 21st, 2021. And this was in relation to what you saw from the vehicle at the parade, not where the vehicle was later found. Any reason why you stated to both detectives in relation to what you saw at the parade, why both detectives in their reports stated that you told them that you observed 3 or 4 people in the SUV at the time of the parade?
So what's your question?
The question is, why did you report that to 2 different detectives on the same evening?
Like I told you before, when I walked past the vehicle, I spotted more than one individual standing in front of the vehicle. So I assumed they were with the vehicle. That's why I said they were inside.
I'm sorry.
That's why I said they were in the vehicle. I said there had to be at least 3 of them in the vehicle. That's the only reason I said that.
So why would you report that you saw this during the parade?
I don't know.
And during both interviews with detectives that evening, the evening of November 21st, 2021, you also stated to both detectives that you observed 3 or 4 black or African American is the word used. 3 or 4 African Americans running from the vehicle. Any reason why both detectives reported that you said that?
No, I don't remember.
No further questions.
Thank you, sir. You may step down.
No further questions at this time.
Thank you. Any cross?
Yes, just briefly. Good afternoon, Mr. Hayes.
Good afternoon.
Thank you for your attendance, sir. Mr. Hayes, do you remember seeing a police officer at this intersection as well?
I don't recall.
Okay. Do you remember writing in your report or telling the police officer that a police officer chased the vehicle on foot?
Objection, leading.
Overruled. It's cross. You may answer.
I do remember that I thought I saw a police chasing after the car on foot.
Okay. And do you remember also telling the same officer that the SUV took off down the street and that it accelerated?
Yes.
Objection.
Is that...
Hold on, there's been an objection.
I guess the objection to be what officer is being referred to wasn't clear.
Overruled. The state may continue asking the question.
I guess I was asking, was that referring to the interview officer?
Your objection is noted. It's overruled. The state may ask the question fully.
Is that your recollection, sir, that the vehicle sped off and accelerated away?
Yes.
Objection speculative.
Overruled.
Do you also recall telling the officer who interviewed you that the driver of the vehicle had a dark complexion and a beard?
Yes.
Is that accurate with your recollection of the driver?
Yes.
But you didn't see a face, you couldn't
No.
identify anybody beyond those descriptions, correct?
Hold on. There's been an objection to leading. It's overruled. The witness may answer.
No.
All right, thank you, sir. Those were all my questions.
Thank you. Any redirects, sir?
Briefly, very briefly, you made a reference to the driver of the vehicle having a dark complexion. What would you consider a dark complexion?
Dark complexion. I don't know.
It is kind of hard. Did you notice any clothing?
I did not, no.
Did you notice any hair?
No.
No further questions?
All right, thank you. You may step down. And you are excused. All right, go ahead, call your next witness.
One thing that he doesn't understand is boundaries, and I think he has zero empathy for anyone around him. He is totally clueless about what he's done, what he's caused, what he's put people through, what he's taken from people. So let's continue on. And these little outbursts that he has, these little talking without being, having the right to talk, it goes on every single day. I think there might have been 1 or 2 days where I was sitting here looking at all this footage and watching it back and going, well, that was actually a calm day. He kept quiet. He did what he was supposed to do. But you're talking 14 days. Well, no, we had over 17 days so far that I've gone through, and I haven't had hardly any of them to where he wasn't mumbling under his breath. And keep in mind, guys, this is all in front of the jury. Not all of it. Not all the time is he in front of the jury, but he doesn't change the way he acts in front of the jury. Like, as if he has it's as if what he wants to say and what he wants to get out is more important than them seeing him do it. Or he wants them to see him do it. It's so weird. It's so strange to me. Like, he doesn't understand the concept that they are a jury. They are going to judge you. They are going to put you in jail. They're going to decide whether or not you are guilty or not. He does not I'm sure he understands that concept. He does not care. Hi, everyone. It's Carrie. How are we? You guys know how we always talk about Brooks with his delay tactics. He'll use anything and everything to keep things going on and on and on so that he can avoid the inevitable. Well, this particular day I found kind of interesting because this was the weather delay. And it's not so much the fact that of what everybody else was saying. It seemed like the judge really wanted to be like, look, let's just call it a day. And Sue Opera was like, nah, I got witnesses here. I got people here. We're coming back. But what was really amazing was Darrell's response, because he wanted to do what was right for the people, for everyone involved. He wanted to be respectful of everyone in the courtroom, and also he wanted to make sure that the televised thing, everything that was being televised, we didn't miss a thing of his trial. What an idiot. Okay. So let's watch this real quick together.
But I may be interrupting if another alert comes in.
And
Mr. Brooks, sorry to interrupt. How much longer do you have? The only reason I ask is there's some weather coming in and I've had some alerts and I want to make sure everyone gets to a safe location. There's a tornado warning, not for us just yet, but so I'll let you finish, but I may be interrupting if another alert comes in. Are they going on? All right, we're gonna take our lunch early then, and all rise for the jury. Sorry for the interruption, Mr. Brooks.
What? Finish my question.
You will. The record should reflect that when we last broke, the court had received information regarding nearby tornado warnings. Ultimately, there were a number of warnings that were issued, some of which affected the immediate area. Our alert system ultimately went off with the lights and the audible voice telling everyone to take shelter. And it has been lifted, and it was lifted just a short time ago, and I had the parties brought back into the courtroom. I know when we broke unexpectedly, It was during the cross-examination for, I believe, Mr. Knapp. And my thoughts are as follows, is to have Mr. Knapp come back in, I presume he's available, and finish his cross-examination. And then frankly, given the severity of the weather that went through, including near my house, and I need to check on my house, is to break for the day. So I know there's jurors who live in the area potentially where some of these things happened. I don't want to question everyone about, whether they have power or whether they don't have power. I just think given the gravity of this case and the weather system that went through, I want to make sure people are giving their full attention, and I would like to then break for the day and then resume tomorrow morning. So that's my plan. As is my practice, though I will give the parties an opportunity to indicate whether they think differently, but that's what I'd like to do. From the state?
I understand, and I certainly respect the court's concern for the jurors and their property and their families.
It's not just the jurors. Let me just say, obviously there's a lot of folks that are here attending. Just what I was following in terms of the weather, it's pretty widespread. There were things that happened more south of here. There were things that happened north and west of here. There's people from all over, and I just think it would be wise to let everyone break for the day and then, check on their things and make sure that there are things that they don't need to attend to as the case may be. So go ahead. Sorry, I didn't mean to interrupt.
Sure, no, and I understand that, Judge. I don't have an argument with that. I just, we obviously have a full slate of witnesses here to go this afternoon. Some have traveled from like the Cudahy area or, some distance, not unavoidable. But my only other suggestion would be to maybe, take an extended break and let people make calls or even go home and check and come back at 3 o'clock or something. If that's a possibility, we could still work for a couple hours yet this afternoon. But whatever the court thinks is best, we certainly will be prepared either way.
I certainly would be open to maybe an extended break so that I and others could do exactly what you just say. But I'll hear from you, sir, if you have any position on that.
Yeah, I do have a position on that. I agree with your first assessment, Your Honor. Mainly because, too, with severity and weather, that can sometimes mess with equipment being the trial being televised. That can possibly interrupt that. And you never know. Some people that may be key to this matter may not be able to come back after an extended break. There's no way to tell at this point. I do believe it would, on the air, just for cautionary reasons, would be wise to kind of break for the day and then reset tomorrow morning or whenever the court feels it's best. I may need to do some checking of my own with some close relatives of my own, and so I would want to
all the
put
people
that
that
on
showed
record
up
as
in
well.
court for him. He don't have any friends or family.
Thank you.
He doesn't have anybody to check in on. He doesn't take care of his children. He's never been a father to them. His baby mamas don't want anything to do with him. His own mother doesn't even come and sit behind him during the trial. But he's going to go check on everybody. He's concerned about everybody. All of a sudden, he's concerned about other people. Is that not what we're getting here? Like all of a sudden? Anyway, I just had to show you this one because I found it amusing as I was getting some of these clips kind of wound down a little bit. So
I heard in their mistrial, but I want to make sure I understand your request for relief and what it is.
This is alarming, to say the least.
Okay, let's revisit this. I'm sure that you guys have seen this before. I know I have. I just haven't looked at it in a really long time. So let's just take a look real quick here, and we'll read this infamous Reddit post. It says this was posted by anonymous Brooks juror 19. Anonymous Brooks juror. That's what it says. I am a member of the jury on this case. Here are my thoughts on the trial and on this subreddit. To start with, I obviously shouldn't be here. I'm not allowed to look stuff up about this trial or really have any connection with the internet, but nobody actually follows sequestering rules anyway. Hence, I am obviously posting anonymously. Accidentally wandered into here a few days ago from the subreddit drama thread on on my main Reddit account. Here is my opinion on the trial. First off, I think it's pretty obvious due to chain of custody that the defendant is in fact Mr. Brooks and he did do it. However, I've had throughout this trial doubts about various aspects of this case. The judge is clearly biased against Mr. Brooks. I got that feeling from when we were in the room, and my eyes have opened to how she acted towards him when the jury was out of the room. Well, how would you know? How would you know if you weren't in the room? Clearly, she is not an impartial judge, and has been trying to belittle, demean, bully, and pull procedural tricks on him fairly frequently. I had my doubts already, but the subreddit has shown it to me clearly. Y'all, this is so stupid. All right, hang on. All right, I got this off of Mashable. It says I need to credit Mashable screenshot via Reddit archives. Okay. Secondly, Mr. Brooks has clearly not been given the chance to plead his case in front of court. He has been silenced and mocked at every turn. While he may be a bit loud or crass at times, I still believe his side deserves to be heard. Now, I do have significant doubts about subject matter jurisdiction. I didn't understand it when discussed in court because the defendant was repeatedly silenced. But I do understand now, thanks to this sub, and I agree that subject matter jurisdiction is a great concern here. This subreddit has made me aware of jury nullification, and I am very grateful for that. Overall, I'm not sure what I will decide. I'm not educated in law, and I have to admit I'm biased against the defendant for the horrible acts he did. However, it is also clear that this trial is a complete kangaroo court. Mr. Brooks has not been allowed to try and prove his innocence, subject matter jurisdiction, or explain the circumstances surrounding the event. It's hard to imagine what could justify it, but we just can't know because of this trial. For these reasons, I'm torn between locking him up and throwing away the key or jury nullification. Both have arguments for and against them, and I'm not looking forward to choosing because Brooks has grasped his heart, y'all. I am mostly writing this to help myself process my thoughts on this, but please let me know what you think. This is the biggest pack of bull maloney. No, okay, I'm not saying Brooks was behind this because we don't know if he was or not. He may not have been. He may not have been behind it, y'all. Darnisha. But I do think that whoever did this did have intentions of screwing with the trial, obviously. It could have been somebody that was just stupid and putting something out there like, like toying with like a game or something. Maybe somebody was doing it to be funny. They thought it was funny and it took off into its own little thing. I don't know. I don't know. I just felt like I don't. Number one, I don't think Brooks did it because I don't think he's smart enough. Okay, first of all. Secondly, if someone did it for him, a lot of people were saying it was Jay Prince or whatever that dude's name is. I don't know. I don't know. Could it have been someone related to his mom, like his mom's boyfriend? I don't even, a lot of people keep talking about Don's boyfriend. I've never seen him mentioned anywhere. So I don't know where everybody's getting that from. So to say that it was somebody that knew him, I really believe that it was somebody making a joke out of this trial because it's so crazy. Like, it's so ridiculous that they were like, this was a humorous, I'm going to post this like I'm a juror. And little Darnisha got his panties in a wad. Okay, so let's go back to what they're talking about in court about this.
Provided to me, which was an email, and then the attachment, which is a color print off. Looks like the person took a screenshot, and that the anonymous post claimed to be a member of the jury on the case, and here are my thoughts on the trial and on this subreddit. And apparently, again, it's a subreddit called Justice for Darrell. All those Justice, the number 4, and Darrell, all no spaces. I then had contact with Captain Dussault, advised him that this should be investigated, and basically turned over the matter to law enforcement for a full investigation. At that point, I made a determination based upon my review of the information that I would not stop what was happening in terms of the trial with the instructions to the jury and ultimately the closing arguments, and then turning the case over to the jury for deliberations. And of course, I am concerned about the integrity of these proceedings, and I will take whatever action that I deem appropriate once a full investigation is done. But at this point, there is no, I would say, credible information that this is in fact a member of the jury. But I will leave that for law enforcement to determine. And if need be, at the conclusion of the case, when the jury reaches a verdict, I certainly will consider whether any questioning of the jurors at that point is warranted. So that's the information I wanted to provide. Again, copies of this information will be provided to the parties, and there is a full investigation underway by the Sheriff's Department. I have no further information about it at this time. I will not be the judge that will further be reviewing it in terms of any requests related to that investigation. I will simply be handling whether any requests as relates to this case in particular.
Oh, he's not going to be happy at all with
the
that.
Copies for the parties. And we'll provide those. Go ahead.
Your Honor.
I'm making sure you was
Go ahead.
first. What is this?
All I can tell you, sir, is that there is apparently on the internet, on a site, or maybe it's an application, I'm not entirely sure, called Reddit. There's a subreddit that is entitled Justice for Darrell, and it was on that subreddit that someone wrote an anonymous post claiming to be one of the jurors. That, of course, would be a violation of the rules that I set up for the jurors, which is why I turned over the information to law enforcement so they could make a full and complete investigation.
For the record, accept for value and return for value these documents. I'm confused.
At this point, sir, I'm providing the information. I trust that the parties will review it, and if a party believes that any request needs to be made of this court, then an appropriate request will be made. But at this point, I'm just advising the parties of the information that I have. And I will add this. I will, of course, it's important that the results of any investigation be turned over to the parties. I don't know how long that will take, but that is also my direction. That was really the only direction I gave to law enforcement, is that
that the results of the investigation that be turned over to the parties.
Was this? Oh, I'm sorry. Was this just found out about this morning?
Yes, the email that was sent to the clerk of court was received at 9:10 a.m. And then that email and the attachment, I'm aware of a second email that was sent to our clerk of court at 10:02 a.m. And I think when we stepped off the bench following the case being given to the jury, I was advised that other emails had been received throughout the court system. And I simply said, obviously that information needs to go to law enforcement. I haven't seen it, haven't reviewed it. But any person who works in the clerk of court's office who has received an email that email about this topic will be forwarded to the sheriff's department. Their forensic unit is handling the investigation, to my understanding. Attorney Upper, did you have a question or something to state?
Yes, Your Honor, I just wanted to state for the record that I have also received similar emails at my office this afternoon. They were sent not to me directly, but to the district attorney's office website. And I only wanted to point out that in viewing the contents of the posting, well, first of all the emails refer to the exact same posting and the language is the exact same in all the postings. In viewing the contents of the posting, we question the veracity of the posting because it refers to things that, quite frankly, are not true. And also, upon reviewing it, Your Honor, we came to the conclusion that it does not exhibit any material prejudice against Darrell Brooks that may affect the veracity of any verdict that may be returned in this case. The posting is largely critical of the court and to some extent the prosecution, but the nature of the posting is actually in support of Mr. Brooks. That's why it's under a subreddit called Justice for Darrell. And I don't believe there's any reasonable reading of this post that would lead someone to believe that it suggests the juror harbors substantial or material prejudice against the defendant.
Thank you. I appreciate the additional record.
Can I say something, Your Honor?
Go ahead.
Oh, Lord. What?
Just briefly skimming through it. I do want to state for the record that I have no involvement with this. I'm really like shocked like this even came to light.
Did you say chocolates? Shock him.
I will say
Perplexed.
just by skimming through it, these are definitely things that have been talked about in the court. So common sense would say that this came from someone that has either been in the court to hear what goes on in the court or a jury member. This is no other way.
Well, actually, the proceedings are live streamed worldwide, Your Honor, available on YouTube worldwide, so I don't agree with that assessment.
Well, I mean, it's pretty obvious that this would come from somebody who's actually, I think it's pretty clear.
Well, I'm leaving it in the hands of law enforcement to do a full and complete investigation.
It's pretty clear, y'all. Oh, shoot.
Extremely concerned about this.
Extremely.
If anything, for cautionary reasons, I believe, Your Honor, that you definitely should take a look at everything I'm saying here and these case laws and
I wish that was her
What's the
typing.
request, though, that you're making
We know it's Leslie, though.
based upon the case
Probably
law
for
that you
Zach.
cite? I heard in there mistrial, but I want to make sure I understand your request for relief and what it is.
You say request for
Relief.
relief?
Like, what are you asking me to do based upon the information that the limited information we have about the Reddit post and this trial?
I guess my request would be, because of the concern of this, to look at a mistrial, or at the very least a discharge of the jury at this time, so this can be resolved. This is alarming, to say the least. This post, and I don't know what Reddit is, to be honest. I've never heard of it or used it, so I don't know the extent of. It's almost like this could be like a snowball type of thing. It can start with something that's this small, and then it can snowball out of control into something totally different.
It sure could. It sure could.
I don't know the extent of this website.
This is just politics.
I don't know who. Well, I think the name of the person who sent the who alerted the clerk, of course, to this post. I think his name is in the email. But then that even begs the question of, how did this person come across this site? What is their significance to this? What is their role in this? It's just so many questions, and
So many
I mean, clearly this points at the court's integrity. It points at your integrity, Your Honor. It's alarming.
Alarming.
It's very alarming.
Somebody gave him
And
that word.
if there's a chance that there can be hidden bias in this jury, it needs to be addressed now rather than later. This is very concerning.
I want to see what the prosecution's doing right now. I want to look at that table, shaking their head.
Well, thank you for bringing up your concerns. Let me turn to the state if they want to respond, and then see what other issues they want to cover this morning.
Judge, the original post was on a subreddit thread called Justice for Darrell. That's the copy that the defendant has in front of him. That post was edited last night, claiming that it was a prank from the start, and that the original poster didn't think it would get that far out of hand.
See, I told y'all.
The way that Reddit works, the only person who can modify the content of the original post is the original poster, and because the jurors have no access to any electronic devices, I think it's safe to say that our 12 jurors back there are not the original poster. So I think that puts that issue pretty much to bed. It's still obviously under investigation because the court takes it so seriously, but there really is no actionable or any real reason why we should doubt the jury's being unbiased in this case.
I object to that on the grounds, Your Honor, that, like you just stated, it's an investigation going on. And if there's an investigation, then that clearly says that something is amiss. We have 15. We have 15 jurors. There's still too many questions that we don't know. Too many. I don't think anything's put to bed because we don't know. It's unfair to say that the issue is put to bed when there's still so many questions left out there. I'm sure you reviewed it yourself, Your Honor. You see the language in this, whatever this thread. I don't know. I don't know what this is. It's clearly a post from somebody who has intimate knowledge of the trial and what's going on in the trial.
They been watching a
I
long
don't
time.
think.
Oh Lord.
I mean, common sense would tell you that this is someone who's very close to the case. Whether they were intending to be funny, whether were intending to try to prank the court or anything like that, we don't know. That could be anybody's guess. The language in this, the way that it's formatted, they lay out 4 specific points of what they think. They point to certain language in the case.
If only they would have misspelled biased.
They make references to saying when we were in the room. They got certain feelings from when they specifically refer to themselves and a group. That would be we, plural. They say, and I have to admit, I am biased against the defendant for the horrible acts he did. And they attack you, Your Honor. They clearly attack you. This is if this is someone's idea of fun, is anybody's guess, but I don't believe that it is, clearly by the way it's formatted and by the language that is in it. This is clearly someone with intimate knowledge of the case and what's going on. Clearly.
They clearly watch long.
There's no other way to interpret this. You can tell by what they're laying out in the language that they're speaking with, if this is clearly someone close to the case. And because of that, it still has to be, I'm informed of the investigation, but there's still too many questions left in the air just from this. How can we put to bed when there's still an investigation?
He is just so.
For all we know, what if this turns up that it was someone on the jury, or what if it turns out that more people are involved in it than just whoever this anonymous person was who left the post? It's too many questions and it's too concerning. What if something like this springs up again at the last minute? We've been going through the trial now for basically 3 weeks, the better part of 3 weeks. And even in court days leading up to the trial, we've never had anything like this happen. Nothing like this has been brought to your attention. Nothing like this has been brought before the court's attention. This just came out of the blue, and now all of a sudden it's being labeled a prank. Is that because they were found out?
It's just horrible.
I mean, it begs so many questions. It's too uncertain. It's too concerning, and it's too alarming. It's too alarming to just overlook and say, "Oh well, we'll just set it to the side and let them." No, this there has to be some type of alternatives, and something has to be done. Something, and if that's a mistrial, if that's discharging a jury, if that's some other type of alternatives that can be looked at, I'm sure that these case law speaks to other options that could come into play. They deserve to at least be looked at.
The jury needs to know, Your Honor.
If anything, to protect the integrity of the trial.
If anything else.
I find it very hard to believe that this close to the trial being over, now all of a sudden these issues are being raised. So this is obviously not a prank, and it's obvious that this is someone with intimate knowledge. It's very clear to me.
It's very clear. Oh my word. Okay. Oh, I love Zach, and I love Sue, and I love Leslie, and I just can't help it. All right. With all due respect, Your Honor, I hope y'all really enjoyed that, because we needed to get that one out this week. Ooh. Y'all have a great week. I love you guys. Okay, so here's the deal. I got this one video that I thought that you guys would appreciate that we're going to kick off the night with, and we'll watch it together. Hi, David. All right, so let's watch this video that I found, or that I kind of clipped earlier today, and you guys will appreciate this.
Madam Clerk is pulling it through, and I will provide the parties with a written copy here in court. It addresses the matter of subject matter jurisdiction.
So we're going to address it?
No, I've issued an order. I'm going to give it to you. That's why I'm addressing it. You can review it later, but there's a written decision now denying your motion to dismiss.
So is that including verified proof that you have subject matter jurisdiction? Because it has yet to be verified or proven.
Mr. Brooks, you keep making that statement, but it's a misstatement of the requirements in the law.
So it doesn't have to be proven?
You are going to get a written decision. That's how I'm addressing this. And then I'm going to have the jury brought out and just providing courtesy copies to the parties as I had an opportunity to finalize that over the break.
I set for value and return for value this document.
That I have not received.
Thank you for noting that. All right, bring the jury out. State has its next witness, I presume, ready to go? Yep. All right. When the jury's brought out, you may call the witness.
Is that verified proof that you have subject matter jurisdiction?
The decision and order speaks for itself, sir.
Is it verified proof that you have it?
Sir, I believe it answers your questions.
I don't believe so.
Unequivocally.
There's no verified proof proving yet.
Yeah, it's the same for both.
There's no verified proof if we're in common law or admiralty law. What court is this?
Sir, I believe your answers will be in that decision and order.
I don't believe so.
Well, have you read it yet?
I don't have to.
Okay.
I accept it for value and return for value, so.
All right, they're in there, sir. It's a final order for
verified proof is in there? Verified proof is in
So if
there?
you'd like to challenge that, you can take that up with the appellate courts.
Verified proof is in there?
All rise.
Because I don't think it is. Proof of claim is not in there either. No one has a claim.
Oh, Darrell. Well, good evening, my little Brooksaholics. How are we? So, I wanted to show you guys something really quick. And this is what I like to call, this is Exhibit 83. Who remembers Exhibit 83? The sticker conspiracy. It's Stickergate. We'll call it Stickergate.
I provided to you prior to you going up on the stand what's been marked as State's Exhibit 83. Do you have that in front of you?
Yes.
Can you briefly identify it for how it's labeled, how many pages it consists of?
What exhibit is that?
Exhibit 83.
It's the Crash Reconstruction Mechanical Inspection Report.
The whole report is Exhibit 83?
Correct.
Yes.
The whole report?
Go ahead. I haven't ruled on it yet, so go ahead and ask your questions, Attorney Basie.
Sir, how many pages does this report consist of?
10. At the top it contains case number and recon number which match my name, the reconstructionist, and then it begins the report and vehicle identification information, and then on the bottom it's marked with exhibit number 83.
Objection. I have the 10 pages, and nowhere on here does it say it's an exhibit. Nowhere on here.
That's because it was marked for purposes of trial. It has an exhibit sticker now. So your objection's noted, it's overruled, and the witness...
privy to the same.
The witness may answer the question. It's been marked as an exhibit. Your objection's noted. It is overruled. Exhibit 83 is received.
So is my paperwork ever going to say Exhibit 83, or is it just going to be this?
Mr. Brooks, I'll take that up outside the presence of the jury later, but we're going to continue. Go ahead.
Brought up in front of the jury.
Mr. Brooks, we're going to continue with the questioning of this witness.
What are y'all trying to prove?
Mr. Brooks, please. No one's. The exhibit, to my understanding, has previously been provided to you. You have it. It's now been marked as an exhibit for trial purposes.
That's something I don't have, though.
Go ahead.
It's not how it's supposed to work. It's supposed to be fair.
Attorney Basie, I trust that this was previously turned over.
It was, and I believe the defendant has a copy of it in front of him.
Thank you.
Where does
Please
it say
continue.
Exhibit 83? It doesn't say that this was
Again,
going to
we'll
be
take
used
this
as
up
an
outside
exhibit.
the presence of the jury later. It's not something we need to do right now. Go ahead and ask your questions.
Thank you, Your Honor. So the first section of your report, and I'm just going to direct your attention to page 3 of Exhibit 83, talks about the tires and the suspension and tie rods. Do you see that?
Objection leading.
Overruled. The witness may answer.
Yes.
And can you describe for the jury what part of the inspection, describe this part of the inspection?
Objection leading.
Overruled. The witness may answer. The report's been received by the court, and the state may direct the witness to various points at its discretion.
Yeah, when was it made an exhibit? Because I wasn't aware of that.
Go ahead, Attorney Basie. You may continue.
Thank you. Sir, can you describe the information contained in the first section of the report under the heading Tires, Wheels, Steering, Suspension, Brakes?
Objection leading.
All right, thank you. You may step down. I will take that. Thank you, sir. And once the witness passes, I'll excuse the jury for an afternoon break. It's just about 3:06. We'll take about 15 minutes. I'll rise for the jury. You can be seated. Mr. Brooks, I know the last thing you said, I heard you say that's hilarious. What were you referring to?
I was referring to, like, are you serious? Some of the same things that I ask on when it's my time to question the witness can be overruled, but when the same thing is done and I object, it's nothing. It's just thrown. It's just thrown to the side. I just think that's funny.
Well,
I
sir,
really do.
I don't find it funny, number one. Number two,
You're not in my position either.
The court rules on the objections at the time that the objections are made. I know, and I wanted to address this briefly. You can have a seat. You had questioned during the testimony of this witness, Exhibit 83, because I believe what you were saying is, and you can tell me if I'm wrong on this, the copy of the report you have does not have an exhibit sticker on it.
It don't.
Right. And
You want to see it?
I don't doubt that your copy does not have an exhibit sticker, because at the time the report was provided to you, and I'll have the state correct me if I'm wrong on this, it would have been provided through the course of discovery. I'd also note that on April, I believe 22nd of 2022, the state filed a notice of expert naming Inspector Ryan Schultz as an expert witness and indicated that he would testify consistent with his report.
And then I directed your attention to the statutes and the rules of evidence dealing with expert testimony, specifically starting at 907.02 through 907.07. That is why I didn't stop during the testimony to have a discussion outside the presence of the jury, because at that point, the objection to not having an exhibit sticker on your report is not would not prevent the court from receiving the exhibit once the proper foundation was laid, which in my opinion it was, and the fact that your document didn't have that specific exhibit sticker doesn't diminish the fact that I know from your cross-examination you were referring to the report. At times you referred to it by page number. It was clear from your questioning that you had reviewed it, and so I just wanted to make...
That didn't come from the report, Your Honor. The only
record
thing
of
that
that
came from the report was from page 9, when I was trying to get clarity about why it said worn tie rod.
Oh, and you actually questioned the witness about the different tire and what that would mean. So I thought 3 good areas of cross-examination that you covered. As far as the other issues I think that you might have when there's redirect, I'm not going to explain what redirect is, sir, but again, for my position, there's direct examination, there's cross-examination. The state or any witness, any party that calls a witness always has the opportunity to ask the direct exam questions and then redirect based upon what's asked during cross-examination. Sometimes that does mean there's some repetition, but I didn't see anything through the redirect of this witness that I thought was improper. So I just wanted to make a record of that. I am going to caution you, sir.
Do you understand what I was saying?
But during multiple times during the questioning of that witness, you were mumbling under your breath. You say disparaging remarks toward the court, toward the witness, or toward the process.
So if it was disparaging, what did I say?
Sir, you say things like it's not fair, or you make noises that suggest like you're disgusted with the ruling that is made.
So you're assuming what I mean by that, and when did I say it wasn't fair?
Mr. Brooks, I'm just making a record because
you're making an incorrect record.
It's important that you demonstrate courtesy and decorum through these proceedings, and that you give respect to the witnesses who are testifying in the process.
Did the witness feel disrespected? Did the witness say anything about feeling disrespected?
Mr. Brooks, I'm not going to engage in this
I don't think
back
he did.
and forth with you because, first of all, it's a mischaracterization of my observations, number one. And
but your observations are incorrect.
It's my job to ensure that under 906.11 that there's the effective presentation, and I'll just refer you to that once again. I'll read it into the record.
You don't need to read it.
Under
906, just make sure that you make a correct
the judge shall exercise reasonable control over the mode and order of interrogating witnesses and presenting evidence so as to do all of the following. Make the interrogation and presentation effective for the ascertainment of truth, avoid needless consumption of time, protect witnesses from harassment or undue embarrassment. Sub 2 talks about the scope of cross-examination. Sub 3 talks about leading questions, and when leading questions may be used to develop the witness's testimony. So with that, we'll take our break. I'll start the 15 minutes. It's 3:13. We are in recess. Thank you. Go ahead.
I did actually take note of when the court overruled one of Mr. Brooks' objections. His response was, stop trying to be slick.
Yeah, I did say that.
So, just for the record, I thought that was very disrespectful.
Thank you, I would agree.
Judge, can we discuss scheduling at some point as well, either now or on the return?
When we come back.
Why wasn't that addressed right when it happened?
Honestly, Mr. Brooks, I'm really trying hard
because
not to highlight
that's the definition of trying to be slick.
During the trial, I'm trying my best here to frankly minimize pointing those things out to the jury and instead pointing them out outside the presence of the jury. You may have noticed I've even started to say I'd remind the jurors that the comments of the parties or the attorneys are not evidence, so as to cast a broad brush and not simply highlight your conduct.
I haven't noticed anything, and I don't
but all right, we're in
refer to
recess.
what
Thank you.
conduct you referring to. If you're gonna be biased, then
Some people were asking about the Waukesha Christmas Parade Foundation, and it is waukeshafoundation.org. They have a link on there that's called the Christmas Parade Fund, where you can go in and donate, and you can see also, what they've done. They've got a Facebook page, Twitter, LinkedIn, all that good stuff. They're doing some great stuff for the community, and I'm sure that in the background they're doing a lot of great things for the children that witnessed this horrific event. Okay, so y'all remember when I posted this and I said, count how many times he says dishonor? Let's count them together.
Record to reflect, we are all back in this courtroom.
before the jury's brought out, can we address subject matter jurisdiction, Your Honor? Before
Absolutely
the jury's
not.
brought out,
Absolutely not.
is that a tacit agreement that you don't have to answer those questions?
He
as a
knows
public
tacit
servant,
now.
Your Honor? So are you going to act in dishonor?
Mr. Brooks,
Are you going to act in
I've
dishonor?
already addressed your requests.
It hasn't been proven for the record, Your Honor.
The jury is on its way,
They're not out yet, though.
but they're on the way.
You held me in contempt.
I'm not
You held me in
addressing these
contempt
matters,
before-
sir.
Have I acted in dishonor, Your Honor? You held me in contempt without me being in dishonor. How have I dishonored the court? Have I acted in dishonor? Have I raised my voice or argued with Your Honor? Have I disrupted the
Mr.
courtroom
Brooks,
in
you're
any
back
way?
in this courtroom at your request. The jury is coming
I
out.
never should have
Please
been.
be respectful of their time
I
and of this
have
process
been. They weren't even
and the
out
dignity
before.
of the proceedings.
They weren't even out before when I was trying to address what needed to be
Mr.
addressed
Brooks,
before they came out.
You're just
Am I
attempting
acting
to
in
disrupt the
dishonor?
proceedings.
Am I acting in dishonor? So that's a tacit
All
agreement
rise
that you
for the
don't.
jury, please.
It's a tacit agreement that you don't have to answer questions as a public servant, right?
All right, the jury
No
is
jury's
not
out.
Mr. Brooks,
No jury's
close the
out.
door.
I was trying to
Mr.
address
Brooks,
this
they
before
are
they
right
came out.
outside this door. I am not going to do this with you this morning. You either
I'm not
abide by
doing-
these rules
Am I
and
acting in
stay
dishonor?
quiet,
Am
or
I
you will
acting
be
in
in the other
dishonor?
courtroom.
Am I acting in dishonor?
Yes, you are acting
How?
in dishonor.
How?
You are disobeying the direct order of this court to respect the decorum and the dignity of these proceedings. You are merely attempting to delay.
I don't care what you think. That's not accurate.
Mr. Brooks, I am having this jury out.
And-
And if you
and you're
say
making-
one word when that door opens,
You're making a tacit
then
agreement.
you will forfeit your right to be present.
So you're acting in dishonor, then, Your Honor.
Jury may come in.
You're acting in dishonor by making a tacit agreement that you don't have to answer any questions as a public servant. You're not holding up to your oath to protect the
All right, the
Constitution.
door is open and he's talking.
Okay, so you're gonna hold me in
All right,
contempt?
the jury cannot come in.
Are you gonna
All
hold me
right,
in contempt?
Mr. Brooks is going to be removed. We're in recess until that
How
can
am
be
I
accomplished.
acting in dishonor?
Go ahead.
Can y'all hear me?
I love it when he's waving from over there trying to get their attention and they're just ignoring him.
Ken.
First of all, at 9:25, I would like the record to reflect that the prosecution was making dispiritive remarks and gestures in pursuant to what just happened. I don't appreciate it, and I think that that is very disrespectful.
Here we go, that disrespectful word
For
again.
the record. And
For the record.
again, I'm trying to figure out how did I act in dishonor to be removed from the courtroom. How have I acted in dishonor? This is a whole nother subject matter jurisdiction, Your Honor. It has yet to be proven for the record. And upon your refusal, that would be looked at as dishonor.
I'm not addressing it. The jury's coming out.
So is that a tacit agreement that you don't have to answer any questions as a public servant, Your Honor? Therefore, that's dishonor. Are you going to honor your oath
previous
of
ruling
office?
stand. I'm not addressing it
Are
further.
you going to honor your oath of office?
All rise.
So I'll take that as a tacit
They
agreement.
probably didn't get Christmas bonuses because they work for the government, but I'm sure that Judge Darrell brought them a nice little gift at Christmas.
But you're not going to honor your
All
oath
right,
of
I'm going to
office?
have to excuse the jury.
I bet, Charlotte, that Barbara has also watched it at least 10 times.
Mr.
Hey,
Brooks, I
Scott Belt
warned you
Sr.
that if you made any interruptions when they came out, you would be removed to the courtroom. That's what I'm doing right now. You're forfeiting your right to be present in this courtroom.
Have I acted in dishonor, Your Honor?
Mr. Brooks, I very expressly warned you.
Have I acted in dishonor?
You have disobeyed a direct order from this court.
Have I acted in dishonor?
You have disrupted these proceedings. Can you pledge that you will respect these proceedings and this jury by not interrupting?
Have I acted in dishonor, Your Honor?
I will ask you one more time. Can you pledge to be quiet, sir?
Why should I have to make a pledge, Your Honor? Have I acted in dishonor?
Because under Illinois versus Allen, I believe you've already forfeited your right to be here, removed to the neighboring courtroom. We will be in recess until that takes place.
Your Honor,
have
I acted?
Court reporters. Those. Can you imagine? Oh my gosh.
Your Honor, have I acted in dishonor?
This court has previously relied upon and 939.63 sub 1 sub B of the Wisconsin statutes. The 28th count of the information in this Darrell sub 3 sub F and 939.63 sub 1 sub B of the recklessly endangered.
Can you guys hear me now? Can you hear me now? Am I muted? I was muted, wasn't I? Again. John Bubba said, the best part is drinking with no pants on at home. Awesome. You know what, John Bubba? I don't know. I don't want to know what the first part of that was. All right. So what I picked up for us tonight is, like, as I was doing all of this, as I've been working on all these clips with old boy, old girl Stephanie and old boy Darrell, there's just a bunch of like random clips. And I put them, like, I haven't even gone through them lately. So it should be fun for all of us. It was what I'm trying to say, because I don't know what we're fixing to watch. But y'all been a whole week without anything, without any Brooks meetings. So I thought that, you get your fix here tonight, okay? Well, Melanator, I'm glad you caught alive too, honey. So let's bring old boy up.
1 second.
Y'all ready to hee-hee and a kiki?
And for the record, I don't consent to that name, Your Honor.
Noted for the record. I intend to have the jury brought out. I presume you're ready to go?
Having a slight issue finding.
Slight.
Can you sit up, because I'm not hearing you very well, so that the microphone picks you up, please?
I'm having a slight issue locating some of the files that I need. That's what I was trying to say.
All right, we'll take a moment. You can tell me when you locate them.
Okay.
In his box fort that he hasn't looked through since he got out of court the day before. Heads up, guys. I talk over this video. I try not to talk over when they're talking, but I do. I might laugh. So if y'all don't like commentary, just most of you like it. See, this is what I'm saying. This is stuff I have not clipped. So, but it just kind of makes you kind of wonder. Like he had no problem whatsoever making everybody wait while he did this. A narcissist at his best, right? Yours was too, show? Yeah, I was having internet issues big time today. Hi, everybody. How are we? Happy New Year. Well, I guess not yet, right? Not yet. Technically, not yet. I am fighting a cold. Well, let me put it this way. I started to fight a cold. That thing kicked my butt. It won that battle. And I'm just going with the flow. It's good to see everybody. So yeah, if I sound funky, that's why. If I break out into a a solo of Smelly Cat, just go with it. Just go with it. Enjoy it. All right, so I put together some clips for you guys that what I like to call best of Brooks. And I don't think I could get all of them in one live stream. I'm just going to be honest because he's so ridiculous. We've got weeks of material here, but I broke it down into some things that I had. And with that being said, let's get started.
The court will call State of Wisconsin versus Darrell Brooks, case number 21 CF 1848. May I have the appearances, please?
Good afternoon, Judge Sue Opper, Leslie Basie, and Zach Wichow, appearing for the State of Wisconsin.
Good morning, Your Honor. My name is Darrell Brooks, Jr. My name is Darrell Brooks, Jr. Say my name. Darrell Brooks, Jr. I'm in the say my name. Darrell Brooks, Jr. It is by special appearance, and I would like to ask, if it pleases the court, that someone can please render the account for me at this time.
All right, thank you. Be seated.
Extremely close with the district attorney's office during the entirety of this matter. Would that be fair to say?
The district attorney's office has been involved in this investigation since the night of, so we have worked closely.
So would it be fair to say extremely close, seeing as how you've been present for the whole trial pretty much?
Can you define extremely for me?
I would like you to define it. Extremely.
I'll answer yes if that helps.
All right, and then anything from you, sir?
In regards to this?
Any other preliminary matters that you are asking the court to address?
Were my filings actually filed? I don't understand the proceedings. And I think that should be stated for the record. If I'm telling you repeatedly, Your Honor, that I don't understand. You can't force me to understand. I'm curious. Some of these, judging by the reports, how are some of these answers allowed to pass when they're coming straight from reports made by the people on the stand? Very curious.
I don't understand your question.
Just for the record, Your Honor, I would like the record to reflect, is that a judicial determination that you are making?
All right, Mr. Brooks, do you have a 13th subpoena? As we discussed yesterday, you wanted to call 13 witnesses. I told you you had until this morning to fill out another subpoena and give it to the state so that they could review it.
Yes, I do.
All right, can you hand that to the bailiff, please? I'll just take a look at it quick. Mr. Brooks, I'm reviewing this for completeness. And you have simply put on here, State of Wisconsin plaintiff. That's an entity. You have to name a person, sir. All right, Mr. Brooks, any further topics by you?
Am I muted?
No, you're unmuted.
I still hadn't even gone through the entire witness list from the prosecution. It's 30 plus pages. That's a lot of names.
Have you ever had any interactions with this entity, State of Wisconsin?
That's a violation of my constitutional rights to try to force something upon me. That's coercion, Your Honor.
Where'd you get this video from, sir?
Objection leading.
Overruled, the witness may answer.
From Mr. Brooks' social media account.
Okay.
The video wasn't even in the exhibits that I received. I actually didn't even receive it.
Mr. Brooks, please stop.
This video is
There
ridiculous.
will disregard his statements. He's not testifying.
Superstar.
I just to be blunt, which I've been since the beginning of this trial, obviously, I see the whole strategy here by the prosecution. I see right through it.
If I have you stay in this courtroom, are you willing to follow the rules of decorum and courtesy?
I do not understand the question you are asking.
Do you have any other issues you want me to address?
Just very, very quick. I still don't understand the nature and cause of the charges against me, Your Honor, and I still would motion for, or tennis motion for the jurisdiction to be proven, the subject matter jurisdiction. And also a motion for finding of fact.
Your requests are all noted for the record, and for the reasons previously stated on this record, I'm not going to answer those requests any further. They've already been denied. Mr. Brooks, you may ask questions of Detective Casey.
Objection, I don't consent to being called that name. Yeah,
Noted. Do you have any questions for the witness?
This when did this video, when was this made a exhibit? Because I don't have it.
Objection, that's not a question for the witness, Your Honor.
That was a question. The question.
Sustained as to the form of the question.
When was this video made an exhibit? That is a question.
I object to the question directed at the witness, Your Honor. It's beyond the scope of his knowledge.
Well, he said he saw it.
But that's not the question asked. So you can rephrase your question if you want to.
When did you see this exhibit? When did you see it?
Am I answering when I saw the video for the first time?
Yes.
Objection, Your Honor. Why is something always funny at that table?
State's directed to avoid laughing commentary. I didn't see it, so I can't further comment. I was looking at
All these
the
cameras
witness.
in here, don't nobody
However,
see nothing.
both parties to show
Come on, man,
decorum
this is not fair.
and restraint. I'm
So
not
is you-
hearing a request from you at this time. You said you wanted to raise a legal issue. What's the legal issue?
The legal issue is how is the state allowed to coach the
You're
people
assuming
getting on
they
the stand?
spoke to them and coached them.
It's obvious. I'm not stupid.
Well, I disagree with that, sir. Are you willing to not interrupt the proceedings with disruptive behavior?
I do not understand the questions that you are asking.
Any other issues at this time?
Yes, I do. The statement of particulars that hasn't been responded to by affidavit. The notice of special appearance hasn't been
I
responded
direct
to.
your attention to the Barnaby decision, sir. The court's not going to be addressing that topic any further.
I saw the video within a few days of Mr. Brooks being arrested. I've reviewed it since then a few times. I reviewed it yesterday and again this morning, and now in court again.
You said you reviewed it yesterday and this morning. If you had seen this video numerous times before yesterday and today, why did you feel the need to view it yesterday and today? First of all, at 9:25, I would like the record to reflect that the prosecution was making dispiritive remarks and gestures in pursuant to what just happened. I don't appreciate it, and I think that that is very disrespectful.
I believe you're choosing not to answer them.
You can believe what you want to believe. I believe that you hiding stuff from the jury. I believe you haven't been impartial or fair. You haven't let me even enter anything into evidence, which is my right to do so. And to your knowledge, why was this video never brought up in your earlier testimony?
Objection, that's a misstatement, Your Honor.
This is mine, by the way. This is mine.
Next question, please.
I don't got no more questions, man.
All right, thank you.
This is mine.
Right.
Nope, I don't understand. Nope. The jury deserves to know who the plaintiff is in this matter. I think it's fair to them if they're to make an informed and intelligent decision. They should know who the plaintiff is.
Do you think I would sit here and be this irritated?
Mr. Brooks, I need to make a record, so just please sit down. There's no need for you to stand at the moment.
I feel like standing right now.
Please sit down.
I feel like standing.
You opened up the door through your cross-exam of Detective Casey about his ability to identify you in that video. You opened up the door for the state to show that video because you directly attacked the credibility of Detective Casey through his knowledge of it and the identification by him of you in it.
She's been laughing and making comments under her breath the whole time during the whole trial, and I never said nothing. I don't know what's being said, but I can tell that it's directed towards me. I'm not an idiot.
Then you need to provide me with the legal basis for that, sir.
So I'm supposed to just come off that with off the top of my head?
Yes. All right, we are back on the record. It is 1:01 p.m. State versus Brooks. Appearances are as they were before. I would note I have instructed, and Mr. Brooks is present in this courtroom. Prior to the, I understand your objections noted.
I don't want to be in this courtroom.
If you would like to go back to the other courtroom, sir, you may, but that is a choice that you would be making. I am not requiring you. I'm not forcing you at this time.
So you're not holding me in contempt?
Sir, I am not requiring you or forcing you to go into the other courtroom. Well, given that he won't answer the questions directly, for now he is to remain in this courtroom.
I'm requesting to not be in this courtroom.
But you won't go through, you won't answer my questions regarding that, sir.
I did. I told you I don't understand.
That's not answering the question, sir.
You asked me a question, I answered it. I don't understand. How can I answer something that I do not understand, Your Honor? But it doesn't matter what we believe, sir. Your Honor. I'm merely stating a request to not be present for these proceedings. I cannot answer the questions you are asking me because I don't understand them.
You understand your right to be present in the courtroom. Are you telling me you
I don't understand anything because I've been over there all morning.
To the place that you are requesting to go back to, right?
You sent me into the other courtroom.
You're right, I did.
Right.
So that's a tacit agreement
All rise
that you
for
don't.
the jury, please.
It's a tacit agreement that you don't have to answer questions as a public servant, right?
All right.
But when I'm making a request to avoid the drama and all that.
Sir, the only one with the drama is you.
So let's
to the other
make the record
courtroom,
correct.
and we
I'm
have
the one
the
that asked
audio
when we came in here, Your Honor.
and video working appropriately.
I asked when we came in here to be present from the other court.
By Zoom because we may have to utilize the share screen in order.
We don't have to utilize no share screen because I'm not going to participate in no proceedings that I don't understand.
The documents.
I told you I don't understand
We're
a
in
million
recess
times.
until we get the courtroom set up.
No, we don't have to be in recess. I don't agree to it. Yeah, would that be, will my objection to that be noted for the record?
It is.
May I request a legal reconsideration of your ruling, Your Honor?
Denied.
May I request a written finding of fact for your ruling, Your Honor?
Denied. Just for the record, it's my understanding that the verdict forms were put in the garbage by Mr. Brooks and they remain in there. Well, I trust the state will object when appropriate, if appropriate.
It's going to be a whole lot of objection then because I'm going to tell the truth. Don't try to come with your slick words and don't put words in my mouth.
Sir, I am not being slick. I'm trying to preserve the integrity.
You've been slick. You've been slick. How's that lawful law?
If you choose not to give one...
How's that lawful law?
You didn't even let me get my sentence out.
You always want to make an incorrect record. Go ahead. Change your incorrect record. Go ahead. You can't rush me to judgment or you can't practice law from the bench and tell me when I can do something and when I can't.
Mr. Brooks, I actually can, under all of the rules of procedure. It is my job to make sure there's effective and efficient administration of this trial.
So then I should be allowed to
then if that's the case, then I should be allowed to tell the jury what they need to know, which is the truth. That they have the power. They have the power to nullify laws that they don't agree with.
You are absolutely not allowed to tell the jury that. There's a jury instruction that I will have ready to go if you even attempt to raise the issue of jury nullification, sir. You have absolutely no right to raise that. That is clear under the law.
I can raise what I want to raise.
It's clear to me you've done your
What
homework.
you talking about? I don't care what you're talking about. I'm gonna let them know that they can nullify any law they don't agree with.
It is a new part of the day. I thought it appropriate to have you brought here.
Why?
And only if you forfeit your right by conduct will I put you back in the other room.
So you going to address subject matter jurisdiction for the record, or are you going to state it on the record?
Okay, then with that, here's Bruno.
Subject matter jurisdiction, Your Honor.
The court's declining to address that further. I stand by my written decision that was entered last week.
So we won't be proving it for the record?
I stand by my written decision that was entered last week, sir.
Judicial determination?
It is a judicial determination.
We would just like to make a record with regard to the concern Mr. Brooks had yesterday about the juror that he believed he recognized from his initial appearance that may have made some type of hand gesture to him.
The juror that you suspected was the woman who made an inappropriate gesture toward you at the initial appearance. They are not the same individuals. I've been able to confirm that. I know the identity of the woman who did what you said, and it is not this juror.
Is there any way that I can be sure of that?
I'm declining to address that on the record for the reasons I've previously provided to you, not the least of which is I have addressed that by way of a written decision.
And it hasn't been proven for the record.
Your objection is noted.
Can I go back in the other courtroom? Because I'm not going to do this with you. I'm not.
Mr. Brooks, I do want to go over
We don't have
jury instructions.
I don't understand the
verdicts.
jury instructions. I don't understand anything that's in these proceedings, and I'm not going to participate in something that I don't understand.
That's your choice, sir.
May I please go back into the other courtroom?
So that's why I cut.
Hi, Brenda. Thank you so much for joining, honey. Welcome to the Hee Hee and the Key Club.
Because there was not anything that you were connecting by way of relevance.
With all due respect, Your Honor, a lot of the questions I ask are
stupid,
objected to. It seems like I can't even get to the questions that need to be answered.
Sir, many of your questions go to these sovereign ideas that are frivolous arguments about the plaintiff and all of that. Ask relevant questions, they'll be answered.
You made reference to questions I asked and being, you said something to the effect of sovereign things. I don't understand what you mean by that. I have no anticipation on your rulings. I'm not trying to sit here and I got enough work to do on the fly. I'm definitely not trying to sit here and trying to anticipate what will be objected to, what will be ruled on in any way. I'm merely just, it was understood that this would be a whole new thing for me to do. I apologize if I'm not as polished as I should be working on 3 days time before a trial. We see all the work that I haven't even gone through.
Mr. Brooks, the jury's coming back in. Again, you could ask
All of a
questions to
sudden-
lay a foundation
all of a sudden the
with
state
these
don't got,
witnesses.
all of a sudden, for the first time in trial, all of a sudden now they don't got no cross. That's clearly a rush to try to get through the case. Hurry up. We just gonna let these people go.
Well, this is argument.
Come on, man.
This is argument on your part,
I
sir.
see
It
through
is pure
I just
commentary
want
at this
that on
point.
the record. I see through it.
And your
Nice try,
see-through.
but I see through it.
It was my understanding that Mr. Brooks did receive the medical attention that he was seeking over the lunch hour. So I just wanted that on the record.
Has absolutely no basis in fact.
Yeah, I know that's what's being done.
So, again, I don't understand nothing you just said, but I don't. How can you deprive me of my constitutional right? How can you trample on my constitutional right?
Mr. Brooks, on the issue of medical attention, did you see the jail nurse or other medical personnel during the lunch hour yesterday?
Yes, I did. I received a cleaning of my cut and a bandage.
All right, thank you.
Oh, I'm sorry. I was getting to the other parts of the injuries. They
Go ahead.
viewed the bruises that I have on my arm and legs as well. I don't know what's gonna happen behind that, but I was looked at.
Might go into medical.
All right, thank you.
May need surgery.
They're your witnesses, sir. If you believe
So I'm gonna start asking every witness up here that they seem just to mysteriously now not have any cross for. Have they been coached to answer the way they answer?
Does not appear to me that any of these injuries are interfering in any way with your ability to be here today and assist in your own defense. So that's good.
Yeah, I'm just a little tender, just a little sore. So.
All right.
I find it very funny that these are their reports, and now all of a sudden you can. Oh, I saw the person in the car. Oh, but
Mr. Brooks,
I
this
saw
is
them
an
reach
attempt
for something.
by you
Oh,
to
I don't.
delay these
I don't recall what they had on.
Mr. Brooks,
You can
there's
recall
no
seeing
purpose
somebody
for you
reach
saying
something
this
and
right
don't
now.
know what they had on. I find that
All right,
very.
I'm having the jury brought
man.
out. I'm instructing you to
Come on,
avoid
man.
the commentary when the jury comes out, or you will
I didn't
forfeit
say-
your right to be
I didn't say
present.
nothing. You.
All right.
Can you show proof of that,
I'm sorry?
Your Honor? Verified?
Give them what?
Can you show a verified affidavit of that?
No. All right.
So as long as the jury's out, we should probably discuss that. I would like to provide the defendant and the court with a copy.
So that had
of
to be said. So it's the defendant.
That's not how it was said.
That was how it said. You want to run the record back?
Is that a judicial determination?
All right. I believe the jurors are coming out. All rise, please.
Are you going to answer that, Your Honor? Or is that a tacit agreement?
Mr. Brooks,
So I'm the only one. I got one.
Mr.
I got
Brooks.
one ear that work, and I heard that.
this
Come on,
is
man.
to benefit
Come on, man.
you so
No,
that
it's
you
not.
understand
Ain't none of this
your
to benefit me,
witness
so let's
has
be clear
a
about
prior
that.
record.
Entering into anything is deceptive in nature. Just right off the bat, that's deceptive in nature. Why would you enter into something that you're obviously not supposed to be into?
You can, based upon your choice and your request, I'll make a finding that he's forfeiting his right to be present in this
I didn't forfeit
courtroom.
anything. I asked.
I understand you've
So I
asked,
didn't-
but
I
I
didn't
feel it's
forfeit
important to
anything.
also make a finding based upon your conduct.
Based upon what kind of me asking?
Are you willing to expressly waive that right on the record right now?
I'm not gonna expressively waive anything.
Come on, man. Like, I don't know who y'all be thinking y'all fooling. I accept the value in return for value this document.
One more interruption and you're going to be...
Anyway.
I did bring these boxes up. I have not had the time to go through everything in there. As you can see, it's a lot. And that's putting it minimal. A lot. So I have not had the time to go through everything that's in there. I'm winging it, Your Honor.
The state of Wisconsin is an entity, it's not a person. The state of Wisconsin cannot testify at these proceedings, so the subpoena should be rejected, Your Honor.
Your Honor, on the grounds that every document that was filed in this matter stated that the state of Wisconsin was the plaintiff, which would lead me to believe that the state of Wisconsin is who's bringing the claim against my client. I do represent myself pro per. I would like that stated for the record. Like the record to reflect that, not pro se.
The record will so reflect your choice of term to describe your appearance today. Are you willing to engage in a colloquy regarding your right to be present and a knowing and intelligent and voluntary waiver of that right?
I am not going to consent to anything that I don't understand, and I will not answer any questions that I don't understand. I'm merely making a request to not be present in these proceedings. I'm requesting a written judicial finding of fact and conclusion of law on this issue for the grounds that I just stated. It was seen, based on the Sixth Amendment, that I'm not being awarded the chance to face my accuser, which I should be awarded that based on the Sixth Amendment. If I'm not able to face my accuser, then how can the claim even stand?
And to be in the other courtroom.
Again, as I've stated numerous times now for the record, I will not answer or comply with anything I do not understand. I'm not making a voluntary waiver of anything. May I state for the record, Your Honor, that I have not even seen a complaint in this matter, and the jurisdiction still has yet to be proven, which is another thing that needs to be challenged. There has not been proven that there's subject matter jurisdiction as of yet. There's no verified proof of it. There's no verified proof of even a claim, especially if I'm not allowed to face my accuser. And I don't understand how you can make that judicial decision, Your Honor, when it's clear discrepancies in the paperwork of this matter. Like I said, I have yet to see jurisdiction be proven. It has not been proven. I have yet to see a complaint. I have not seen that.
All right. Start with the jury instruction.
You'll
There
start
is
with,
one I
you'll
would
start
like
with subject
to.
matter jurisdiction?
No, I've declined that already, sir. I'm not going to address
Under
that
what
further.
law? Under what lawful law?
We are in the middle of trial. Your objections are noted. We will continue today with the jury trial.
For the record, may I respectfully move for interlocutory appeal on this matter, Your Honor?
Your request is noted for the record. I'm not an appellate court, sir.
For the record, may I move to stay these proceedings until this instant matter is adjudicated by a court of competent jurisdiction?
Your request is denied.
Based on what law or fact, Your Honor?
I've previously addressed the issue, sir.
So
based on law of the case.
Are you making a judicial determination that I'm not awarded my Sixth Amendment right to face my accuser?
I'm not making any such determination here today. All right.
What law or fact?
I'm going to turn to the district attorney's office. Do you have a witness available?
Yes, we're ready to proceed, Your Honor.
All right, our jurors here. All right, the jurors will be brought out, sir.
Your Honor, with all due respect for the record, you're avoiding my questions.
Mr. Brooks, I've addressed the issues that need to be addressed this morning. I've also addressed the same issues probably every day we've been in court. I know you may be dissatisfied with the response that I'm providing to you, but my responses stand.
It's not a dissatisfaction, Your Honor. It's a lack of understanding, which I don't have. I don't even understand the true nature and cause of the charges. And without
Mr. Brooks, you've been made aware of them multiple times.
I do not understand them, is what I'm saying.
I encourage you once again, if you don't understand anything, to seek the advice of an attorney. I cannot give you legal advice.
I'm not asking for that, Your Honor. I'm merely asking why are my constitutional rights being prejudiced? It states under the Sixth Amendment that I have the
Sir,
right.
I've already addressed this. Okay. We're not going to have any further argument on this topic. All right. Your Sixth Amendment rights are being honored no differently than any other defendant that has appeared in my court.
Have any other defendant not been awarded the opportunity to face their accuser?
You are facing your accuser, sir. Every single witness who's been on this stand, you have cross-examined.
None of those witnesses are making a claim. None of those witnesses are the plaintiff. None of those witnesses are identified as the injured party. An injured party has to make the claim, Your Honor. A
Sir,
living.
it's my opinion that your belief as it relates to that is mistaken. It's not a lawful argument, and it's frivolous. I've direct your attention once again to the Beneby decision.
Is that not a federal case, a United States?
You're asking me for legal advice. I'm not going to provide that to you, sir.
I'm just asking what kind of case it was. Was it federal Supreme Court
It's a Seventh
case?
Circuit Court of Appeals case. We're in the Seventh Circuit, sir.
But you just stated that you're not a court of appeals. But you're citing a court of
No, but
appeals
Court of
case.
Appeals case law applies to this court, sir. I'm bound by legal precedent from the various courts that are above me.
And you're still not explaining how I'm not able to face my accuser, which is my Sixth Amendment constitutional right.
Sir, I'm not going to explain the law to you. I've made my decision. It stands.
I'm not arguing that part of it, Your Honor. I'm just merely stating for the record.
Yeah, I heard the door. Okay, thank you.
I'm merely stating for the record that I should be awarded my Sixth Amendment right to face my accuser.
Your objection is noted, sir, once again. We'll continue this morning. Thank you.
None of the witnesses that testify are the accuser. None of the witnesses that testify are the injured party, which a claim has to be made by a living, breathing human being.
Sir, I think you're confusing civil law with criminal law. That's what I'm saying.
No, I'm confusing. I'm not confusing any law. The Constitution says that I have the right to face my accuser. And under the Sixth Amendment, I'm not being awarded that constitutional right. I think that definitely needs to be on record, and that definitely is the issue that needs to be raised.
Your objection is noted, sir. If you believe I've erred in that regard, you can raise that issue on appeal if you are convicted.
May I put Your Honor on notice that I intend to appeal that decision?
Your statement's noted for the record.
Is that a judicial determination I will not be able to face my accuser, Your Honor?
I have not made any such determination, sir.
Will you be making a judicial determination?
Sir, I have not made any kind of determination that your Sixth Amendment rights have been violated. On the contrary, I believe this court has honored those rights.
Even with me not being able to face my accuser, which is the state of
Your
Wisconsin.
position is noted, sir.
Is
It's
that
noted
a judicial
for the record. I've already addressed it.
Is that a judicial determination?
Sir, the record speaks for itself. I'm not going to answer that further. I've answered it multiple times.
Is it a tacit agreement?
It is not.
Then I should be awarded my Sixth Amendment right to face my accuser. Or a judicial determination should be made.
Record to reflect that the jurors are coming in for the morning. Good morning, ladies and gentlemen.
The record should also reflect that I received no answer to that question.
And then you forfeited your right to testify in your behalf. I'm not going to revisit those, sir.
I'm not asking you to revisit them, but I'm just they weren't correct.
Whew. Is he wearing y'all out yet? We're not done. Hang on. I got to switch over to another stream because I've got more coming up. I just had some stuff done. But I did want to play this part one more time.
Good afternoon, everyone. The court will call State of Wisconsin versus Darrell Brooks, case number 21 CF 1848. May I have the appearances, please?
Good afternoon, Judge Sue Opper, Leslie Basie, and Zach Wichow, appearing for the state of Wisconsin.
Good morning, Your Honor. My name is Darrell Brooks, Jr. My name is Darrell Brooks, Jr. Say my name. Darrell Brooks, Jr. I'm in the say my name. Darrell Brooks, Jr.
I like that part. All right, and we got another clip here coming in.
All right, good morning, everyone. The court will call State of Wisconsin versus Darrell Brooks, case number 21 CF 1848. Record should reflect that the state appears this morning by District Attorney Sue Opper, Deputy District Attorney Leslie Basie, Assistant District Attorney Zach Wichow, and the defendant Darrell Brooks appears in person in custody. I'd also like the record to reflect that he is appearing in jail attire today. He's also wearing a mask.
I object to that, Your Honor. I do not identify by that name and would like the opportunity to state that I'm here concerning this matter as third-party intervener in this matter, appearing as authorized representative for my client. I accept for value in return for value all the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments and would like to now reserve my rights, if I may.
Mr. Brooks, you just interrupted me within a minute of us starting this case here today. I'm asking you to respectfully not interrupt me. That's the second time, so I can go through the list of things that I need to get through this morning.
I just wanted it stated for the record that
Mr. Brooks,
it
wasn't the proper time to do that. That's now the third interruption. So,
with all due respect, Your Honor,
Mr. Brooks, by saying all due respect doesn't change the fact that you're interrupting me. Your objection is noted, all right? But you need to stop interrupting me so I can get through what needs to be done. I have a number of documents that I need to discuss this morning. Mr. Brooks, you do not have a right to interrupt the court. I will remind you once again of the Supreme Court rule. It's on a yellow laminated, double-sided piece of paper that is before you. I checked, I verified, it is.
I accept it in return.
Mr. Brooks, that's yet another interruption. Let me get through this, please.
Non-responsive answer is a tacit agreement, Your Honor. Can I have the originals for all my filings?
I'm not going to address that right now, sir. I don't have time, frankly, to look through everything that you filed to determine whether we've given you originals or not. In the future,
I have the copies. I don't have the originals. Subject matter jurisdiction, Your Honor.
The court declines to address that.
Still has yet to be verified and proven for the record.
Your objection's noted.
So while we're on the record, may I challenge the subject matter jurisdiction?
No, you may not, sir. You need to file a motion in order to do that.
So
Mr. Brooks,
motions I filed haven't even been responded to. I gave
Mr. Brooks, you're interrupting me yet again.
You just weren't speaking.
All right,
so
Mr. Brooks, you are now going to be removed to the other courtroom.
I don't consent to that.
I have had a dozen or more interruptions. We'll be off the record while we do that. Thank you, everyone.
I don't agree to a stop. I move for a motion to dismiss for being under duress and being coerced into a contract that I did not consent or agree to. I do not. I have a right to be present for trial.
Coerced.
Let me know when you've had an opportunity to review it if you so choose.
I just stated for the record, I accept for value in return for value document.
All right, I'm going to move on.
I have them here.
This is taking up valuable time with the jury. We need to keep going.
Is that a judicial determination, Your Honor, that I can't get an answer to something?
I don't believe there's any other preliminary issues we need to address unless preliminary other than the filing, sir, and other than the topics we've discussed this morning. I know you're holding up your objection sign, sir, but I am giving you the opportunity to come back over here. Would you like to come back to this courtroom? Record should reflect he's holding up his objection sign. It appears that he's writing I don't know what, of course. Mr. Brooks, I'm going to ask you again. Would you like to come back to this courtroom for opening statements?
So I'm on the record.
You are. If you would please address my question.
So you want me to come back over there just to get brought back over here?
Can the title man please direct the prosecutor to answer whether their assessment for the charges
Mr. Brooks.
in her possession.
No one's going to be answering these questions, okay? I'm not requiring the state to do that. I'm advising you to stop asking those questions. It will be considered an he's interrupted. Take him to the next courtroom. I'll make more findings when he is in the courtroom next door, and I can do that without an interruption.
Or agree to a estoppel, and I will move. It's even been put on record numerous times with inaccuracy. Even what happened today, nobody reported on record about me being bruised up and having to get bandaged up. How are you even a judge?
All right, you may step down, ma'am. Thank you.
How are you even a judge? Come on, man. This must be all about the 62 trust, right? That you want to be the beneficiary of?
I'm going to give the jury their closing instruction. We are done with testimony for today. Please do not begin your deliberations and discussion of the case until all the evidence is presented. And I have instructed you on the law. Do not discuss this case among yourselves. The fourth count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin. Count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, 939.50 sub 3 sub A and 939.63 sub 1 sub B of the Wisconsin statutes. The sixth count of the information, contrary to section 940.01 sub 1 sub A, 939.50 sub 3 sub A, and 939.63 sub 1 sub B of the Wisconsin statutes. The defendant has entered a plea of not guilty to each one of these charges of the victim named in that count. Cause means that the defendant's acts was a substantial factor in producing the death. 2, as to each count, the defendant acted and statements, if any, and from all the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason. With that, I
don't agree to that, Your Honor, or consent to that.
Your lack of consent is noted.
And also for the record, I don't consent to the name that's being referred to.
I'll use this opportunity, sir, to ask what name you prefer to be called, because we now have evidence in the record where you provided your name to, upon questioning. There was video from when you were taken into custody, and then, of course, Detective Carpenter has testified about that as well. And we've been given no other name, sir, by which to call you by.
Do you see these boxes I got right here? Do you think I was able to go through everything in those boxes?
Mr. Brooks, I'm not going to go through this with you again where you attempt to put on the record all of these issues that you have when we're in the middle of a trial. Come in contact with the parties, lawyers, interpreters, or witnesses. Do not speak with them. The issues presented. Do not investigate this case on your own or visit the scene either in person or by any electronic means. Do not read any newspaper. Please rise for the jury.
Thank you. You don't call yourself a judge as much as bias you put up in here. Don't even tell the jury the truth. Got no integrity whatsoever. None. None.
Thank you, everyone. Please be seated. I would like an update on whether Mr. Brooks filled out a subpoena for Dawn Woods and provided that to the state. Has that been done?
No, we haven't received anything, Your Honor, and obviously she can appear here voluntarily if Mr. Brooks wants to arrange that. I don't believe a subpoena is necessary. Our position would be, Your Honor, that we will not be responsible in any fashion for producing Ms. Woods' Mr. Brooks talks to her on a daily basis. If he wants her here, he can produce her on Monday.
Yeah, they ain't got to worry about that.
So I just wanted to know, because I know a subpoena form was filled out.
If I want her to be here, she gonna be here.
I agree with
So
the
just
state that
know that.
she could certainly appear.
It ain't even got to be no arrangement. All I gotta say is come. She gonna come. That simple.
Mr. Brooks, do you intend to call her as a witness? Because I'm directing you to have her
We
here
said
at
all
9
that. We said
a.m.
all that at the beginning, man. Like, I don't even want to be in here that much longer. Just do what you got to do so I can get up out of here. I'm tired of being in the courtroom that has no integrity whatsoever. How can you even call yourself a
Mr.
judge?
Brooks, I need to make a record of some
I need to
things.
make a record too.
You don't
When
need
am
to-
I going to get the chance to do that?
All right, I need to make a record. He's being removed to the other courtroom. He is yelling at me. He's not going to let me make a statement or make the record that I need to make. He
leave
hasn't
anyway,
sat
so
down
what do it matter?
for
You
the
can
better
hold me
part
in
of 2
contempt all
hours.
you want. You can hold me in contempt all you want.
I'm not
All
holding you
gotta
in
do is tell me
contempt.
if it's criminal or civil, so I can hit
Right.
you with you.
I need to
with
clear
what you
the
know is
courtroom because
coming.
I do need
I'm
to
gonna
make.
give you what you know is coming.
I need him to go to the
If
other
it's civil-
courtroom because I do need to put some
if
things
it's
on the
civil,
record. The record should
Where's the
reflect
contract between you
that
and I?
Mr. Brooks
If it's
is
criminal,
yelling at me.
what is the crime?
He is.
Who makes the claim? And what
He
is
is. I will make the record when we get back. I will step off, but Mr. Brooks, you're being
It ain't
taken
no
to the next
It ain't no Mr.
courtroom.
Brooks. Don't try to address me
Thank
like
you.
that, like we cool. You don't have no integrity. How can you even call yourself a judge? Making tacit agreements, being biased, judicial misconduct, trying to steal somebody's system. It seems to me that all y'all been wanting to do is gang up. Be biased, be prejudiced, and gang up. 4 against 1.
I can't read your sign, Mr. Brooks. Can you hold it up closer?
Thank you, Mark, for gifting those memberships.
If it's a pledge that you will not interrupt me, I will bring you in for what will be the final section of my remarks today in the sentencing portion.
I think you should give him that opportunity before you go through
I'll do that.
sentencing factors. And I can only read the top where it says objection, but
I can't tell what it is, what it says. He can bring the sign with. We'll clear the courtroom. We'll take a short break, and I will bring him back in. But I will warn you, Mr. Brooks, if there is one interruption, you will go back to that room because you will forfeit your right to be present for the sentencing portion. The record should reflect that it's 4:53. Mr. Brooks is back in this courtroom. Mr. Brooks, the only way I will honor that request is if you specifically waive your right to do so. Without that, that's not a convenience for you over there. It's you go over there when you frankly demand removal under Illinois versus Allen.
Demand anything.
No, your conduct did. So you
My
can
conduct
sit.
didn't demand anything either.
Right, Mr. Brooks,
You
please
keep
sit
changing-
down.
You keep changing
And I'm
the
going to continue
jurisdiction.
with my sentencing remarks.
You keep changing the jurisdiction. Jurisdiction, it's a subject matter jurisdiction that has yet to be proven on the record. In
Mr.
that court
Brooks?
and in this one.
Please sit down.
I would like to go back to the other courtroom.
It's not a courtesy to you. If you'd like to specifically waive your right to be present, then I will entertain that. Otherwise, you need to sit down.
I never waived the right to not be present.
That's
I
because
had
you
to-
forfeited your right
I
to be
didn't
present
forfeit
by
anything, Your
conduct.
Honor.
You're
I
now
wrote-
back in this courtroom.
Your Honor, I wrote 3. I did what you asked me to do.
You
said,
never once pledged to me, sir, that
No.
you would not interrupt. And
You-
you're demonstrating by being here that you continue to interrupt.
Man, I ain't trying to hear all that because at the end of the day, I did what you asked me to do. You told the bailiff to tell me.
Mr. Brooks, this is not a debate.
You told the bailiff to tell
It's
me
not
that
a
I had
debate.
to
You
write.
asked to come over here, and I honored that,
Well,
and
I
I brought
exercised
you
my
back.
right 3 times. I shouldn't have had to do it 3 times.
None of those opportunities that you wrote to me said, I pledge to not interrupt.
I never
Judge
had to do
Doral."
that before. You've never required that before.
That is actually.
You've never required that before. Every single time that I've been brought over there, after some time, sometimes very short, sometimes an extended
Mr. Brooks,
period of time.
you are just simply trying to delay the inevitable. Please sit
I
down.
don't care about the inevitable. It was
I need
already
to
written
get
from day
through
one
this
what was going to
hearing.
happen. It doesn't make me lose any sleep about that. I know I'm okay.
I'm okay with everything.
Then please sit down.
I just want to be treated fairly, which I have not been.
Please sit down.
And then Your Honor, and then you
Mr.
always make it seem
this is
like
not a
you always
debate.
make it seem like it's some type of aim, and it's not.
Please sit down.
We're talking about constitutional rights. You just told me, or you told the bailiff to tell me that I had to exercise a right that I should already have. I did that. Not once, not twice, 3 times. And it still wasn't honored. And then I raised this sign. I'm waving this for like 20 minutes, saying I would want to come back. I'm doing this.
You're here now.
Can I come back? Can I come back? Can I come
sit
back?
down.
It wasn't honored. And then I said,
can finish.
I'll write this, and I'll see if Your Honor can see it on the screen. The objection sign saying, I exercise my right to be present.
If you stop for a
May I
minute,
have the order of the court?
I'll explain it, but you have to stop I can explain it.
Your Honor, I did what you asked me to do.
Actually not.
Yes.
Let me explain if you would like.
If I didn't, Your Honor, if I did not do what you asked me to do, then why was I allowed to come back if I did not do what you asked me to do?
Because I'm frankly going to a very distinct portion of this hearing where I am going to impose sentence.
Okay, that doesn't answer the question, though.
Matters.
That doesn't answer the question.
Please sit down and I will explain and remain quiet without interrupting me.
With all due respect.
That doesn't mean you're respecting me, so please sit down.
With all due respect, you told the bailiff when I first said, because every time that I've been brought over there in the past,
Mr. Brooks,
you always stated,
I don't need a history lesson of what I've done.
That when I exercise my right to be present,
Untrue.
You've always said,
Untrue.
We have the record. We have the record. We can dig into the record.
Mr. Brooks?
I know what the requirement was of me going over there. You've always stated on the record that when I exercise my right to be present, you will bring me back if I will follow the rules of decorum. That's your exact words, which you said every time.
Which you're demonstrating right now that you have absolutely no ability to do.
With all due respect, I've never had to go through any type of certain words that needed to be said or stressed or anything like that before. I've always done it the way that you've asked me to do it. No different than today when I told the bailiff I would like to be present. You told the bailiff if he wants to be present, he has to put it in writing.
And pledge to me that he will not interrupt me.
I put it in writing.
Without a pledge.
So why am I here?
Because I'm going to move on to another phase of this hearing, and I thought it important that you be here in person.
So I was here.
But you didn't reclaim your right to be back here.
Then why am I here then, Your Honor?
Allowing it to happen.
And I respect that you're allowing it, but still, it doesn't answer the question, though, Your Honor. It does not answer the question.
Mr. Brooks.
Your Honor, as a public servant, I have the right to ask questions of Your Honor.
I'm going to ask you one more time, and if you refuse to sit down, then you are in direct disobedience of a court order. Sit down and be quiet so I can make the appropriate record.
Can you tell me what the court order is?
He's not going to obey. He's now forfeited his right to be present. He will go into the other courtroom.
I didn't say I wasn't going to obey.
We'll be in recess until he's there.
I just asked what is the order. I didn't say. It's not about me trying to interrupt you, Your Honor.
Mr. Brooks, I'm going to address the next one, so please pay attention.
What you were saying about decorum, I was asking, does that fall under the First Amendment? Because the First Amendment, which is my constitutional right, says that I have the right to freedom of speech and to be heard in this court.
Mr. Brooks, again, you have the right to present a defense, but that right is not unfettered. That right, Mr. Brooks, you are interrupting me. Stop.
Because you're talking about
no, because you're purposely doing this, so I can't get my reasoning out. You make it incredibly difficult.
I'm not referring to the Sixth Amendment.
Mr. Brooks,
to the First Amendment, which clearly says that I have the right to freedom of speech and to be heard in the courtroom. Are you not going to honor my constitutional right, Your Honor? If not, that is judicial misconduct, and you're making a judicial determination to not honor my constitutional right. I just want to be treated fairly, like anyone else, which you said on the record that you will be fair and impartial.
Mr. Brooks, you also have an obligation to treat this court fairly, and you have an obligation to follow the rules of courtesy and decorum, the rules of procedure, the rules of evidence.
Your Honor,
that's the playing field that you willingly entered into and made a deliberate decision to waive your right to an attorney and to appear in this case as your own attorney.
To represent myself pro per. The same paperwork that you gave me, you have, and I also have a copy of the same one where I scratched out what I did not agree or consent to. We both know that, Your Honor.
Mr. Brooks, I made findings regarding that, and those findings stand. That despite you scratching out some of those words on there, I made very specific findings about your waiver of right to an attorney. So we're not going to relitigate that here right now.
You also accepted the terms of the paperwork that I filed
Mr. Brooks, I'm not going to engage with you about whether you and I have entered into some type of a contract.
We did not.
Or engage in any type of that kind of dialogue, because that's what you're claiming through some of these filings, and you've said that previously.
I am not claiming that, Your Honor.
So,
in any way,
Mr.
shape,
Brooks,
or form,
I am giving you some leeway. You continue to talk over me. It's I'm asking you to follow the rules of civility. Simple rule, sir. Don't interrupt me.
Did I not just let you read the whole jury instructions and follow the rules that you said I have to write down?
You did.
Anything that I object to and then hand it in.
Except now that we're discussing them, it seems to me that the rules don't quite matter to you, sir.
No, that is not what's being asserted.
Here's what's happening, sir. I'm telling you, I'm advising you to respect the rules. I'm advising you that if you continue to interrupt, you risk forfeiting your right to be present in this courtroom.
Are you?
Because I still need to continue with these proceedings, sir. I need to go through all of the documents that you filed, and you're not letting me do that.
Because we didn't
So
get
I'm
past
gonna,
the
if
issue.
I need to, I'll remove you to the other courtroom so that I can do this. And yes, exercise the mute button, sir. And then I'll bring you back when the jury's back.
This was filed, though, Your Honor, and it's a valid.
Mr. Brooks is clearly not following the simple rule of civility that I have established. He continues to interrupt. He's not providing this court with ability to make rulings on the record without interruption. So this is your final warning, or you will be removed to the other courtroom.
Will Your Honor honor my First Amendment right?
I'm not answering that question, sir, because I've already addressed it.
So you're making a judicial determination to deprive me of my constitutional
I am not
right.
making any such determination, sir.
So you just said you're not going to answer the question about my First Amendment right, which says
Sir,
that
I've
I have
already
freedom of
answered the
speech.
question that you have a right to present a defense.
That is the
You have
Sixth
a right
Amendment,
to
not
be
the first.
present.
You're trying to twist
You
up the
have
amendments.
a right to present your defense, but your rights are not unfettered.
Yes, they
your
are,
rights.
Your Honor. You're citing the Sixth Amendment, which I am not
Mr. Brooks,
questioning.
Your First Amendment, in some respects, is circumscribed by the rules of evidence and the rules of procedure.
Does it say that I have
So it doesn't
freedom of
mean you
speech?
get to say anything that you want in
No,
front of
I'm-
a jury.
Your
And
Honor.
it doesn't mean you get to put forth any kind of evidence that you want
Your
in front
Honor,
of a
am
jury.
I
What
being-
it means, sir,
am I
is
being
that you
disrespectful?
must
Am I
follow.
calling you
Yes,
out your
you're being
name? Am I threatening
disrespectful because
anybody?
you're
I'm not doing anything of the sort.
All right, he is continuously talking over me. So at this point, I'm going to find that he's forfeited his right to be
I have
present
not
as I
forfeited
go
my right,
through
Your Honor. I have
his
not consented to any. I'm
his
simply trying
paperwork. He's to be
understand
removed to the other courtroom
I'm
until
simply
such
trying to
time as he
understand
can pledge to
why we're
follow
not
the
talking
rules
about
of
the First
decorum and
Amendment. I'm not
civility.
talking about the
We'll be
Sixth
in
Amendment.
recess until we have
Your Honor,
everything
I do
set
not
up.
agree to a
The record
estoppel.
to reflect, I'm stepping off. Based upon Erica Patterson's testimony, who, by the way, she showed grace and dignity facing you, the man who clearly has no regard for her as a mother of one of your children, as someone you had a domestic partnership with and a relationship with at one point.
That's not true.
We know, and I would say this goes to your character, what was shown through that altercation and going up the hill, following her, slapping her. You know, the rules don't matter to you. not the rules of the road, not the rules established by court orders, not the rules even of decorum and decency. And I'll get to this more fully when I talk about your character. We know that on November 20th, and she was very contrite about this. She told you where she was. She invited you out there. And that you had contact with her on the 20th. There was some physical.
Contact with her on the 20th.
Mr. Brooks, this is my time. You need to not interrupt.
That's the reason why the charge was dropped.
Mr. Brooks,
the state
you need to stop.
said specifically, wrote you, Your Honor, and said that they know it was no incident that day.
Mr.
And
Brooks,
now you want to sit up here.
Do not interrupt me or you will be removed to the other
courtroom. And now you want
courtroom.
to sit up here.
Stop.
And try to
now.
add something in that you know for a fact never even happened. You want to sit up here
Mr.
and talk
Brooks,
about
every
who has
time-
grace and all this. You talking about someone with 5 kids that don't have custody.
You need to stop
None of
right
them.
now or you will be removed.
Remove me then.
All right? He will be removed. He cannot simply stay
I don't
quiet
consent
when
to
this
being
court talks.
sentenced anyway. I don't consent to this. Just like I told you, I don't know the.
You'll be in recess until he's
I don't
removed
even
to the other
understand
courtroom.
the true nature and cause.
Mr. Brooks, my question to you is, do you have any position on the state's proposed jury instruction? Otherwise, I'm going to rule on their request.
You're gonna rule on the request anyway. I got a lot of questions that don't get answered.
I have to rule on the request, sir. It's been a proposal filed with the court.
You haven't ruled on subject matter jurisdiction yet.
Yes, I have.
No, you
In
haven't.
any event, do you have a position on the jury view, sir?
Yeah, what about subject matter jurisdiction?
One last time, Mr. Brooks, do you have a position on
Can
the
I
state's
go over the
proposed-
document, please? Can I do that, Your Honor?
sorry?
Respectfully for the record, may I do that? You seem like the same thing that was there yesterday.
It's not. There are some changes.
What changes?
Reference
It's
to
the same.
the-
It's the same document that was
Reference to
accepted for value and
the-
returned for value yesterday. The same document.
It's not the same. The changes were put on the record verbally by the state. It's taking out reference to Sallyport of the Waukesha County Jail. Now, you also mentioned previously, when I referenced going back to your cell to get the list, I'm giving you that opportunity. You asked me to do that.
I did not ask you to do that. The question was, where was the list at?
That's true. So you said the list was in your cell. I'm advising you that I'll give you the opportunity
I
to
don't
go.
want to do that.
Can I finish? I'm advising you that you are being given the opportunity, if you so choose, to go back to your cell to obtain the list of witnesses that you have been working on. Further advising you that if you choose not to do that, your one option would be to verbally tell the court any additional names to what you've already provided. Write those down for the court so that either tell me now or write them down so that I can include them in the list of names I'm providing to the jurors.
So how am I supposed to do that without the list in front of me?
The list that you have in your cell?
How am I supposed to do that without the
I'm
list?
telling you, I'm giving you the opportunity to go get that.
I'm not
So,
gonna go do that.
Mr. Brooks, I'm not gonna play games with you.
And
I'm giving you
I'm
an
not gonna-
opportunity.
and I told you
You
that I'm
either
not
go to
gonna
your
do that.
cell and
You
get
said
the
I have the
list or
opportunity
not.
to do that.
All
You
right.
said I have the opportunity.
I'm not gonna
going to do
demand that
that.
you do it, but you have to understand, sir, that if you
I
choose
don't
not to
understand.
do
I
that.
don't understand. I don't understand.
All right,
I've
Mr.
made
Brooks.
that clear. I don't
You
know how
claim
many
to not
times for the
understand,
record.
and that's been made very
No,
clear
I don't
here, sir.
understand. You're not
So-
going to get me to consent to something that I don't consent to or agree to. I do
know.
not
All right.
understand. Just
Mr.
like I
Brooks,
don't
we're gonna
understand the
take a
nature and
recess
cause
so
of
that
this.
the court can get this
exactly
information
like I've
from
been
the
telling
state.
you from the beginning.
Okay, he's continuing with his disruptive behavior. It is his choice to do that. Mr. Brooks, you are hereby warned, once again, if you continue with that, you will be removed from the courtroom.
Remove me. Remove me.
Requesting to go to the other
Remove
courtroom?
me. I told you that before I even came over here.
Sir, are you requesting to
I
go?
told you that before I even came over here.
Mr. Brooks, are you
That
requesting?
It was pointless of me to come over here. You can smile all you want and
Sir,
think it's funny.
my
I don't take this as a joke. I don't take this as a game.
My preference is for you to be
You
here.
expect me to answer all these questions that you have for me, Your Honor, but you have yet to answer one question that I've asked you. You have yet to verify anything.
You can take them back to the other room. It has been disruptive.
You haven't even honored my request to make an offer for my appeal.
Thank you, ladies
You
and
haven't
gentlemen.
even
We'll have to
honored- you
clear
haven't
the
even done that.
courtroom.
I don't agree to a stop and I move this court.
We do have 2 witnesses here ready to go. If the next witness goes relatively smoothly, would you consider letting us call the second one and maybe wrapping up by about 6 o'clock?
Yes.
Okay, thank you. If not, he can come back tomorrow, but he's been here twice already.
No, we'll keep going. I prepped the jury for that yesterday, so we're good. I'm gonna have the jury brought out. All right. Bring the jury in, Madam Clerk.
And I object to that.
To the timing?
Yes.
Your objection's noted. We're gonna make up for lost time from yesterday.
So can we adjust the subject matter jurisdiction?
No,
then,
we
since
cannot.
we're talking about that? We're not gonna address that either. That's still not gonna be proven, right? That is frivolous stuff. That's gonna get pressed every time, so. I've yet to prove subject matter jurisdiction, any jurisdiction at all, right?
The jury will disregard the comments being made by Mr. Brooks at this time. They are a mischaracterization of the law.
Absolutely not. They are absolutely not. Are you aware of who the plaintiff is in this matter?
Objection, relevance.
Grounds?
Mr. Brooks, not now.
Not allowed to.
Not now. The jury is in this courtroom and you will show respect for them and for this court.
Respect for them would be
Mr. Brooks.
telling them the truth.
Stop. I'm putting you on notice that you are on the verge of this court creating a curative instruction about your frivolous arguments. I will not have you claim legitimacy for what are debunked, frivolous, sovereign arguments.
Then
That is
prove
why
it.
your questions
Prove it.
are being
Prove that it's
objected
frivolous.
to.
Prove
and
that it's
why
frivolous. Prove it.
all the cases that we've already referenced, sir. We are in recess. We'll be back
And
in
prove
5
it.
minutes. Thank you, everyone.
I don't agree to a estoppel. Can you prove?
The favorite part when he's muted.
Nobody reported on record about me being bruised up and having to get bandaged up. Was not. And I would like the record to reflect that you have not shown verified proof of subject matter jurisdiction whatsoever. And that by refusing to answer, that is a tacit agreement by you, Your Honor, which you understand what that means. I know you do. Can I go back in the other courtroom? Because I'm not going to do this with you. I'm not.
You
Give me the chance
interrupt.
to
You don't wait for
state my
anyone
name.
to finish.
I don't consent to being called by the name that this court chooses to identify me by. I want to state for the record that I'm here as a third-party intervener on special appearance on behalf of my client. Can that be noted for the record?
It was noted this morning.
May it be noted again for the record so that we can keep the record clear and accurate.
I'll make a finding that he's forfeiting his right to be present in this
I didn't forfeit
courtroom.
anything. I asked.
Let the jury know that when they come
So
in.
are
Yes.
you overruling the fact that the true nature and cause has not been presented to me? That I don't know what the true nature and cause of the charges are? For the abstain, Your Honor.
Next question.
So I can't get no grounds. Okay.
That's a new song.
I'm not
I can't
making
get
a
no ground.
voluntary waivery of anything.
So there'd been the subpoena sheet that would have had, your name and, a number of different.
What do you mean my name? What are you referring to?
I believe it would have said Darrell Brooks on it.
Are you aware that I don't identify by that name?
Objection, argument sustained.
Sustained.
Sorry.
I laughed.
Are you willing to
at him.
expressly waive that right on the record right now?
I'm not gonna expressively waive anything. I'm seeking to merely understand.
Sir, I cannot give you legal advice. I cannot give you the understanding that you want. I need to make an appropriate record.
I just told you that I don't understand the questions you're asking. What do you want me to do? You seem like the same thing that was there yesterday.
It's not. There are some changes.
What changes?
Reference
It's
to
the same.
the-
It's the same document. That was
Reference to
accepted for value,
the
returned for value yesterday. The same document. Now, please go back into the other courtroom. Not allowed to.
Not now. The jury is in this courtroom and you will show respect for them and for this court. Sorry, was there an objection?
Yes.
The basis for the objection?
Relevancy.
It is relevant. It is received, 51B.
The objection be noted for the record, Your Honor.
It already has been.
I can't answer something I don't understand.
I believe you're choosing not to answer them,
You can
sir.
believe what you want to believe. I believe that you hiding stuff from the jury. I believe you haven't been impartial or fair. You haven't let me even enter anything into evidence, which is my right to do so. I want to
Stop interrupting me.
You were quiet. I didn't.
Mr. Brooks,
Respect for them would be
Mr. Brooks.
telling them the truth.
stop. All right. Bring the jury in, Madam Clerk.
And I object to that.
To the timing?
Yes. It is my right to do so or to not do so.
If I have you stay in this courtroom, are you willing to follow the rules of decorum and courtesy?
I do not understand the question you are asking. It is frivolous, though. That's gonna get pressed every time. So I have yet to prove subject matter jurisdiction, any jurisdiction at all, rather.
The jury will disregard the comments being made by Mr. Brooks at this time. They are a mischaracterization of the law.
Absolutely not. They are absolutely not. I don't understand.
All right? You willingly waived your right to an attorney. I made all of those findings, so we will go
You
forward.
made those findings,
I
but
am
they-
not obligated to answer questions.
made
When you
those
ask me
filings.
questions, I'm going to mute him.
So while we're on the record, may I challenge the subject matter jurisdiction?
No, you may not, sir. You need to file a motion in order to do that.
So is that a judicial determination that you're making?
My decision on the record stands, sir. Mr. Brooks, you do not have a right to interrupt the court.
I always thought of Newton as gravity. So that was a bit of new information. I'd like to go back over there, Your Honor.
So my
I
question
feel-
to you is, do you want to come back to this courtroom, sir?
So I can get sent back over here, because as soon as I say something, I'm going to get sent out. Do you see these boxes I got right here? Do you think I was able to go through everything in those boxes?
Mr. Brooks, I'm not going to go through this with you again where you attempt to put on the record all of these issues that you have when we're in the middle of a trial.
You can't force me to stay somewhere that I'm making a request not to.
I cannot explain court procedures or the law to you. So with that, Mr. Brooks, that's another interruption. You keep going. Stop.
Not an attack. It was not planned, plotted.
Bring the jury in, Madam Clerk.
And I object to that.
To the timing?
Yes. This was not an intentional act. Quote unquote jury view. So you want me to come back over there just to get brought back over here? I just stated for the record, I accept for value in return for value document.
Mr. Brooks, you just interrupted me within a minute of us starting this case here today.
I'm still trying to understand the whole process. I just want for the
You
record.
will have an opportunity when I give you an opportunity. No one else
stated-
is speaking at the moment but me. You need to stop interrupting.
I don't identify by that name.
I believe we are using the accurate name.
did
I
not
checked, I
recognize
verified,
that.
it
I
is.
accept it and return it to
Mr. Brooks,
value,
that's
Your
yet another interruption.
Non-responsive answer is attack agreement, Your Honor.
Jury's coming out.
Can I at least raise the issue of subject matter jurisdiction? That's
No, there's no lawful motion before the court. You may not. Audio
I don't
means to
consent
participate.
being removed from the courtroom, Your Honor.
That's another
And
interruption.
you haven't shown me any lawful case law that I from the court
Mr. Brooks?
proceedings in a trial and forced under coercion and duress to appear in the trial that I am needed, that I've tried to express. No, like the record to reflect, I still haven't received my original copies of my filings here this morning with the timestamp. With all due respect, I do not agree with that assessment whatsoever.
Do you have a position on the jury view, sir?
Yeah, what about subject matter jurisdiction?
Mr. Brooks, did you hear the question that I asked you?
And I respectfully keep the position that I just put on the record.
Brooks?
Motions I filed haven't even been responded to. I gave
Mr. Brooks, you're
3-day
interrupting me
No,
yet
you
again.
just weren't speaking,
All right,
so I didn't
Mr.
interrupt.
Brooks, you are now going to be removed to the
I
other
don't
courtroom.
consent to that.
I have
I am
had
under
a
duress
dozen or
by
more
having
interruptions.
shock- I
We'll
have
be
shock-
off the record while
shocks
we do
on my
that.
ankle.
Thank you,
I don't
everyone.
agree to a stop. Or I move for a motion to dismiss for being under duress and being coerced into a contract that I did not consent or agree to. I don't consent to being called that name, Your Honor,
I understand,
for the
sir.
record.
And I have advised you previously that I will continue to refer to you at times by that name, as I believe it's appropriate given the charging instruments in this case.
Was my ICF obtained by clerk of courts?
The one requesting the copies of various documents?
The one asking for the complaints.
Yes, my understanding is they're working on it.
Just wanted that clear for the record.
I do
I
need
don't-
to,
Your Honor, or consent to that.
your lack of consent is noted. And the jury will be brought out and you'll be asked to call your next witness.
Being called that name.
So noted.
And we still need to address subject matter jurisdiction before the jury's brought out.
I will not be doing that.
Will it be proven for the record?
The record stands.
So is that a tacit agreement that you don't have to answer that question, Your Honor?
I make no such agreements with you, sir.
So that means you can answer a question then. Will we be addressing subject matter jurisdiction on the record, and will it be verified and proven?
Understands that a lawyer may be
Formed,
appointed if the
I never
defendant
said I
is
understand.
indigent and understands the disadvantages of
Never once said
self-representation.
I understand.
He is voluntarily and freely waiving the
As a
right
matter
to
of
be
fact, I do not
represented by
understand.
counsel and is making a deliberate choice to proceed without counsel. And therefore, the court will grant the motion to withdraw brought by Attorney Perry and Attorney Keyes. And from this point forward, Mr. Brooks will proceed as his own attorney.
I don't understand what is going on.
I believe you do. Please sit down. The jury's coming in.
What do you mean by complaint?
The complaint would be a reference to the charges in this matter.
Are you willing to not interrupt the proceedings with disruptive behavior?
I do not understand the questions that you are asking. I'm trying to seek to understand how the testimony evidence that was given could be
Mr.
considered
Brooks, I've already
evidence.
dealt with that. I'm not going to deal with it. If
Your
Madam
Honor,
Clerk, have the jurors brought
Your
in,
Honor,
please.
What you're doing is judicial misconduct. You're making the judicial determination, and I'm not allowed to ask questions. Again, as I've stated numerous times now for the record, I will not answer or comply with anything I do not understand.
Well, given that he won't answer the questions directly, for now he is to remain in this courtroom.
I'm requesting to not be in this courtroom.
But you won't answer my questions regarding that, sir.
I did. I told you I don't understand. I've merely brought up subject matter jurisdiction because it has merit. I've merely tried to seek to understand the proceedings that I do not understand. You're rushing me to judgment by constantly removing me from the court when I should be present for all proceedings, and I should be able to understand, which I do not.
That's not answering the question, sir.
You asked me a question, I answered it. I don't understand. How can I answer something that I do not understand, Your Honor? Once again, I do not understand the charges, the nature of the charges against me. I do not understand why Your Honor will not answer mere questions that would give me clarification on understanding. I'm not attempting purposely to be disruptive, disrespectful in any manner. But if I don't understand something, it benefits me to ask so that I can have clarity. You always state that. You always state that.
To sit down and to pay respect to this court, to these jurors, to the process.
It is my right to stand or to sit, Your Honor.
All right, let me start with the jury instruction.
You'll start with, subject
to.
matter jurisdiction? I'm seeking to understand, Your Honor.
Mr. Brooks, final warning.
I'm seeking to understand, Your Honor.
In addition, sir, parties are able to file requests with the court. It's called a motion.
But it doesn't matter what we believe, Your Honor. I'm merely stating a request to not be present for these proceedings. I cannot answer the questions you are asking me because I don't understand them.
You understand your right to be present in the courtroom. Are you telling me you
I don't understand anything.
Right?
Nope, I don't understand. Nope. Will my First Amendment right, which is freedom of speech.
That's Mr. Brooks. I cannot explain to you if you don't understand the basis in law for the denial.
You're right. I don't understand. But
but that doesn't mean we're going to have a discussion or a debate about what it means, because we're not going to do that.
The rules that you set.
So the bottom line is, I don't feel, Mr. Brooks, stop talking.
Issues.
When I asked you where you hold me in contempt, you said civil.
Respect the decisions that I've made.
They're not
interrupting.
They're not correct decisions, Your Honor. It's kind of funny that they disappeared. No ICF disappeared before.
Not evidence, sir. So
they haven't disappeared before. I've always got copies. What's the difference now? Heard why you were getting them before?
My understanding is they were forwarded to me, sir. But
So what happened to this one being forwarded to you?
Sir, I can't answer that. I can't answer what I don't know. So
It
the jury's
like
coming
to
in. We're going
avoid
to continue with the trial. No, I've declined that already, sir. I'm not going to address
Under what law? Under what lawful law? Did you get a license plate number of the vehicle?
Your 90611, move on to a new topic, please.
I understand that.
I can't answer. You asked me questions. You asked me questions. I didn't answer them based on my understanding. How can you force me to understand what you're asking me if I don't? And then you still make a finding based on that. How is that lawful law?
Mr. Brooks, I stand behind the record that I've made today.
And that's fine. I'm not arguing with you about what you ruled. I'm saying, how can you do that without my consent?
If you continue to raise issues that I've already
That's a violation of my civil rights.
If you continue to raise these issues, sir, and thwart the purpose of this court, which is to finalize the jury instruction and the verdict forms, you will forfeit your right to be present in the courtroom, and you will appear from the other court. These rules are intended to assure that jurors remain impartial throughout the trial. If any juror has reason to believe that another juror has violated these rules, you should report that to me. If jurors do not comply with these rules, it could result in a new trial
involving additional time and significant expense to the parties and the taxpayers. You are to decide the case solely on the evidence offered and received at trial. With that, you are excused for the evening. All rise for the jury, please.
It's weird how he gets an evil face right here all of a sudden. Look at
I
his
just have a
eyes.
couple of housekeeping matters. Please be seated.
It's out of nowhere.
My recollection, there's been a couple of exhibits that were annotated and captured so that it's notated on the record. And so there's a cover letter, and then there's some documents pursuant to your request. I'll give that to and then along with, on the back, will be that incident report. So that's being provided as well. And then the state, you'll get a copy of that incident. Then, just, Mr. Brooks, those things were provided to you?
Yeah, I set the value in terms of value these filings. And just very briefly, so we can get out of here. I have to raise this issue.
What issue is
My understanding, how can someone who's not an injured party testify on behalf of somebody who is an injured party?
Mr. Brooks,
and it still be
I'm
charged?
not addressing this. It is a frivolous argument. You have a misunderstanding of the law. We are in recess. I am leaving the bench. Thank you,
Okay.
everyone. We're in recess.
So that's a tacit agreement. We're not.
I
What
think
will
that's
the
fair,
motion
Your
be?
Honor. It's a motion to conform the information to fit the evidence.
Oh, all right. I'll take that up.
We'll have it in writing for Mr. Brooks in the morning, Your Honor.
Okay, that'll be great. All right. Anything else from you, sir?
No, I redid the. It's not the exact order that I'm gonna call the witnesses, but it's pretty much
Who you want, like each time block, morning or afternoon?
exactly.
You'll be ready to
It's
go
just
tomorrow?
not an exact order like I'm gonna call this person.
I'm
this
not gonna hold you
person.
to that, as long
Yeah.
as it's by time blocks, if you wanna call it that, but be ready to
Well,
call
I'll get
witnesses.
it just so I can state for the record, so it'll be easy to follow. I did the names by threes. I'm guessing the first three would be the morning, the next three would be the evening.
I'm
and
so
then
glad it
Friday,
explains how he did it.
3 morning, and then 3 evening. Is that fair?
It was so hard to follow.
I think so.
Yes, we may be able to move faster, but we will attempt to stay in contact with the witnesses if we can, bring somebody here sooner. If the court's got time, we'll do that, but that's very reasonable.
And then do you have any idea how long you anticipate your opening will be?
Opening statement?
Yes.
I don't think it's any way to gauge how long it will be.
Just be mindful, sir, it's not the time to make argument, opening statements, as I like to call them, and what the jury instruction references, it's the roadmap. So I will expect to hear a lot of the evidence will.
I love that part where they make fun of him. Let's watch it again.
Any way to gauge how long it will be.
Just be mindful, sir, it's not the time to make argument, opening statements, as I like to call them, and what the jury instruction references, it's the roadmap. So I will expect to hear a lot of the evidence will show, the testimony, things of that nature. If it turns into argument, that's what happens at the close of the case.
What do you mean by argument?
If you're trying to argue the evidence and what it means.
No, I'm not trying to argue.
But this will be what, basically to lay out what the defense, what I would expect is for you to lay out what the defense or defenses that you believe you'll be presenting evidence about will be. And to kind of, again, give the jury a roadmap, an idea of what to expect as your witnesses come forward.
And Your Honor, just one other quick thing. I know that you asked the defendant if he had any questions that he wanted you to ask. I would just, the issue that he's brought up with being deaf in one ear, I'd also ask if he has any questions of yesterday's panel that maybe he's unclear,
or didn't hear anything, although he didn't notify anyone he was having trouble hearing. He was answering questions in the other room without the headphones on. Actually, he was given the headphones. It took him a minute before he even thought to put them on. But just to see also if he has any questions, obviously he's got to follow the Supreme Court rules, but if he wants to ask the jurors any questions, either from yesterday's panel or today's panel, any concerns that he may have about any of them.
I would agree that that's a good procedure to employ, Mr. Brooks, so you'll be given that opportunity. I would note he does not have the headset on here. I can make a further record that previously especially when I went through the waiver of right to an attorney, I realized that was in this courtroom, but he at times would answer, I hear you, or I heard you. But Mr. Brooks, you're advised that if there are any follow-up questions on anything you didn't understand or you believe you didn't hear, we will have all of the jurors at one point that are remaining from yesterday and today brought in the courtroom. All of them have numbers, and you'll be able to do follow-up that is appropriate. Now, you also mentioned previously when I referenced going back to your cell to get the list. I'm giving you that opportunity. You asked me to do that.
I did not ask you to do that. The question was, where was the list at?
That's true. So you said the list was in your cell. I'm advising you that I'll give you the opportunity to go.
I don't want to do that.
Can I finish? I'm advising you that you are being given the opportunity, if you so choose, to go back to your cell to obtain the list of witnesses that you have been working on. Further advising you that if you choose not to do that, your one option would be to verbally tell the court any additional names to what you've already provided. Write those down for the court, so that either tell me now or write them down so that I can include them in the list of names I'm providing to the jurors.
So how am I supposed to do that without the list in front of me?
The list that you have in your cell?
How am I supposed to do that without the list?
I'm telling you, I'm giving you the opportunity to go get that.
I'm not going to go do that.
Mr. Brooks, I'm not going to play games with you. I'm giving you an opportunity.
And I told you that
either
I'm not
go to
going
your
to do
cell
that.
and
You
get
said
the
I have the opportunity to do that. You said I have the opportunity.
I'm not going to demand that you do it, but you have to understand, sir, that if you choose not to do that.
I don't understand. I don't understand.
All right,
I've
Mr.
made
Brooks.
that clear. I don't know how many times.
You claim to not understand, and that's been made very clear.
I don't understand. You're not going to get me to consent to something that I don't consent to or agree to. I do not understand.
All right.
Just
Mr.
like I
Brooks,
don't
we're going to
understand the
take a
nature and
recess
cause
so
of
that the court can get this information
exactly like I've
from
been
the
telling you
state.
from the beginning.
Okay, he's continuing with his disruptive behavior. It is his choice to do that. Mr. Brooks, you are hereby warned once again, if you continue with that, you will be removed from the courtroom.
Remove me. Remove me.
Requesting to go to the other
Remove
courtroom?
me. I told you that before I even came over here.
Sir, are you requesting to go?
I told you that before I even came over here.
Mr. Brooks, are you
that
requesting?
It was pointless of me to come over here. You can smile all you want and think
Sir,
it's funny. I don't take this as a joke. I don't take this as a game.
My preference is for you to be
You
here.
expect me to answer all these questions that you have for me, Your Honor, but you have yet to answer one question that I've asked you. You have yet to verify anything.
You can take him back to the other room. He's been disruptive.
You haven't even honored my request to make an offer for my appeal.
Thank you, ladies and gentlemen. We'll have to clear the courtroom.
I don't agree to a stop and I move this court for a motion to dismiss.
The record should reflect
The record should reflect that my rights are being trampled on. This is ridiculous, man.
Okay, this right here is audio from the other courtroom that we didn't see him, but it's just the audio. Somebody left the mic on. Hot mic.
As soon as I raise the issue, I'm being disruptive. I'm intentionally trying to be disruptive. I'm intentionally doing this. I'm intentionally doing that. So I should have just stayed over here, which ain't even legal to do anyway. Can't be present and not present when it should be a motion. This is ridiculous, man. This is ridiculous.
Okay.
You're forcing somebody to agree to something that they ain't agree to. Y'all come up with anything y'all can. Anything y'all can, huh? Why I need that in here? You could have left that over there. I'm going back over here anyway.
Just in case.
If I'm right here in front of the face, I don't have no problem hearing it. That's why these could have, I'm going to have to go back over there. Y'all know that.
We'll bring it with us.
I'm just saying, man, this is ridiculous, man. This is ridiculous.
Excuse everyone from the courtroom, take a recess so that the test result could be obtained and if necessary by reasonable
COVID
force.
results.
It's my understanding there was some type of situation or altercation between Mr. Brooks and the deputies. Ultimately, though, I think he was taken into the bullpen. He was brought back out, but it was very clear to me that he was upset. I think understandably so, but I needed to make a record of what was being done, including that I have obtained the test result, so there's an accurate record in this case related to the motion that was raised previously by Mr. Brooks. I want Mr. Brooks to know that I am not removing him from when the jurors are brought back in. It was just simply because he was upset. He was very loud when I walked into the courtroom before going on back on the record. He was yelling about his constitutional rights being violated. I advised him that if there was any type of use of force that he wanted to complain about, he could certainly do that through the proper channels with the sheriff's department, but just given his state of agitation and my need to make a record, I had him taken to the other courtroom. He is currently muted. I do not intend to go forward with additional testimony. Ultimately, I'm going to take an early lunch break because of this, but I will make a record of the following. I have the result. I am going to scan it, have my clerk scan it. It will be filed as confidential, though. It won't be available to the public, but it's there for appellate purposes, but I can confirm that the test result for COVID-19 was negative. And again, I required the sheriff's department to provide that result to me, and it was, and it will remain under seal. I realize I'm disclosing that result, but I feel obligated to do that given the motion that was raised 2 days ago by Mr. Brooks. Again, I intend to take an early lunch, so that will hopefully give Mr. Brooks an opportunity, if he so chooses, to review the result himself. It was put in front of him. I did see that he either shoved it or tossed it or just dismissed it. It looked like it went on the floor when it was put in front of him, but we'll certainly have the deputies give that to him again. During the recess for lunch, Mr. Brooks will also be given the opportunity to change into street clothes if he so chooses. But when we come back, he will be in this courtroom. I agree. Mr. Brooks was making a couple of statements about how he was abiding by the rules and being respectful, things of that nature. I agree. He's done an excellent job while in court here this morning. He's been respectful of the rules. He made some early on. I let him, make his objections or lack of consent. He did that respectfully. When I said I was moving on, he generally was able to do that. We were able to get through 2 witnesses. He was able to follow along, ask cogent, clear,
Here comes the crying.
responsive and articulate objections. He was able to elicit information from the witnesses regarding either their memory, their credibility, and other things. Generally speaking, he's been able to competently represent himself and provide, again, solid cross-examination this morning. So I'm going to give him an opportunity to hopefully settle back in and to come back here when we return from lunch. So with that, we are in recess. Probably come back at 1 o'clock, since it's only 11:30, and we'll take the full 90 minutes for lunch today. Thank you.
Oh, poor
There we
thing.
are. Let's get all of our audio on. All right, we are back on the record. It is 1:07 p.m. Appearances are as they were previously. Mr. Brooks is in the courtroom. He is in jail attire, as that is his choice. And I don't know if there's anything the state wants to address at this point before we continue with testimony.
No,
Just
thank
wanna
you.
check. All right, Mr. Brooks, anything you want to address at this point? It's hard for me to see his head. He's bent over, but I thought I saw him shaking his head. No, but I'll ask one more time. Mr. Brooks, anything you want me to address before the jurors are brought out to continue with testimony from witnesses?
Just a little emotional right now.
All right. Let's bring the jury out. We'll continue. I
Happy
presume the state
birthday,
has a
tall
witness in the room.
glass.
We do. All right. Thank you.
Hey, Casey. He's emotional because it's about him.
Mr. Brooks, the jury is headed out, but why don't you hold off on that, and at the next appropriate time when they're not on their way in, I can address whatever it is. Or if you want to pass me a note, you can do that as well.
Oh, he gonna write a note. Jason's putting us all on notice to have a happy 2024. That's funny. Oh, that would tick him off big time, Judy. If Erica got up and said, oh, guess what? They're not your kids. He can't stand it when it comes to her.
Tell me the topic. We can cover it verbally.
The topic is pertaining to exculpatory evidence. Some things were learned, and once they came to my attention, I felt the need to immediately address the court about this information.
All right, what information? Make an offer of proof for me, sir.
The expert witness for the prosecution in regards to I believe it was inspecting the vehicle. Officer Ryan Schultz, question was asked of did he know if there were any recalls on that vehicle, and I believe that a Brady claim should be visited because there were in fact recalls on that vehicle. In fact, there were recalls on the Ford Escape models from 2008 through 2010 in regards to the throttle body malfunctioning and causing the vehicles to accelerate and not being able to be stopped. There is a class action lawsuit where Ford Company were sued because of this, and those vehicles models from the year 2008 through 2010 were recalled, and that is very important information in regards to the vehicle in question being a Ford Escape 2010. This information is very easily obtained just by pulling it up, and you will see a class action lawsuit. Obviously, if it's a class action lawsuit, then it's pretty easy to.
So what's your request, sir?
My request is to find out if Officer Schultz knew, to find out if the prosecution knew that there was a recall on those vehicles, and in light of the fact that these vehicles were recalled because of this malfunctioning throttle body for I believe it's counts 1 through 73 to be dismissed.
All right, what's the response from the state defendant?
Thank you, Your Honor. As Trooper Schultz testified during his examination, consistent with our research, there are no active recalls listed for the Ford Escape. As Trooper Inspector Schultz noted during his testimony, that Ford listed an extended warranty for the throttle body on the Escape. The warranty was extended to 10 years of age and 150,000 miles. The Escape is more than 10 years old and has more than 150,000 miles. Also, he noted specifically in his report that he did not note any defect in the throttle body as previously described in this report. There was no recall in the throttle body. NHTSA did do an investigation into allegedly defective Ford throttle bodies, which would have impacted this year. Basically, the electronic throttle body failures would have resulted in engine stall or surge while entering traffic from a stop position or while driving at highway speeds, neither of which I believe occurred here. Further, Inspector Schultz would testify that that does not prevent the brake from working. So if this had been activated on this car, which it was not, but if it had been, and this defendant would have pushed down on the brake, it would have stopped the car. Further, if this was a problem, there would have been the malfunction indicator lamp or the wrench light would have been illuminated, as Trooper Schultz or Inspector Schultz testified when he started the vehicle and checked the indicator lights. None of them were lit. Further, if there was this, he would have observed material buildup on a commutator. There was no such buildup observed. There were no problems with the throttle, electronic throttle body. That was part of his report. Therefore, this is, although there may have been some cars who had this problem, the car that the defendant was driving on this day did not have that problem.
In other words, no. Nice try, but no. Mary Carol Hooper, Thank you so much for becoming a member, and congratulations to Casey, Noreen, and Tall Glass for your anniversaries on the channel. Budgie Girl, that's so kind of you, honey. Thank you so much. I appreciate you. And also Miss Patty. Thank you so much, Miss Patty.
That was testified during the vehicle inspection. The defendant had the opportunity to cross-examine Inspector Schultz with regard to that. And again, in running the defendant's mom's VIN number through NHTSA, National Highway Traffic and Safety Administration. There are, for this particular VIN number, for this car that the defendant was driving, 0 unrepaired recalls. So it's a moot issue.
I don't believe it's a moot issue. And I actually have, the report should be in the mailroom as we speak. I had everything sent over priority mail, the actual information about the class action lawsuit, the actual information about the recalls for those models, like I said, 2008 through 2010. Now, in all fairness, Your Honor, that's why I was asking for a Brady claim on this. Seeing as how when vehicles are purchased from the manufacturer, they're still sold as is. There would be no way to know that there's anything malfunctioning with the vehicle until it actually happens. And seeing this a class action lawsuit, no one would sue the Ford company if there weren't malfunctioning vehicles. There would be no class action lawsuit if these vehicles were not malfunctioning. And I believe with that, like I said, the information is easily obtainable. I should have the information in the mailroom right now that you can readily view this information about the class action lawsuit, about the recall. It wasn't just the 2010 model in question, it was 2008 through 2010. The information about the malfunctioning pertains strictly to the throttle body.
Let me address your claim, sir. So, not trying to cut you off, I don't need the specifics about a class action, because as it relates to this case, the fact that there's a class action would not mean there's a Brady violation by the state. In fact, you even indicate it was readily known and something you were able to find out. I'd further note that you had a full and fair opportunity to cross-examine the inspector regarding his mechanical inspection. It's not new information. And more importantly, as it relates to this particular vehicle, based upon the testimony of Inspector Schultz, it's speculative as to whether this vehicle would be impacted, number one, by the class action, and number two, any throttle body problems. Because, again, there was a full inspection. That report was provided to you. He testified on direct examination about there being no active recalls, and more importantly, he testified about what impact the throttle body would have and what he would expect to see if there were any issues with it.
Now to that exclusive jailhouse interview. Prosecutors say he took deliberate steps to maximize the carnage when he targeted families as they celebrated Christmas. But if you think the suspect in that parade rampage is a monster, he's got a message from behind bars. Words hurt. In his first comments since the attack in Waukesha, Wisconsin, the suspect is complaining to Fox about being demonized as he sits behind bars.
Brooks told our reporters, "I just feel like I'm being monster demonized." He answered questions, but he did not explain why he attacked all those innocent people at the Christmas parade. Brooks explained that no one, not even his mother, has been to see him at the jail.
Darrell Brooks's mother is sharing her opinions on the verdicts today. 12 News' Caroline Reinwald spoke with her, and she joins us now live. Caroline.
Joyce, she tells me the trial has been
Okay, you guys in the chat that aren't getting along, just watch your tongue, please. I know that not everybody's going to get along. I know we all have different opinions and everything, but I really enjoy all of you guys being here, and I do appreciate you have different opinions, but just stay off of each other's backs about what everyone's opinion is, because that's their opinion. They're allowed to have it, and they're allowed to put it here in the chat. So please be nice to one another. Y'all gonna make me go all mom, and it's New Year's Eve, and I don't want to go all mom. For crying out loud, Barbara Seals just gifted 10 memberships. Thank you so much, honey. You're so kind. Thank you.
difficult for her to process. She also says her son is mentally unwell, though she did share her thoughts for the victims and their families as well.
The hate was stopped, the hate mail was stopped, the hate emails that I'm receiving was stopped, you know, and people's hearts began to heal. My heart still goes out to the family. My condolences to all of them, but I hope that they can begin to heal.
My condolences, but
Dawn Woods, the mother of Darrell Brooks, says she did not watch the verdict live today, but learned from loved ones of her son's conviction and says she's not surprised. When your son said that he didn't mean this wasn't intentional, did you believe him?
I know my son. I know it wasn't intentional. People who are mentally ill need help. In community, family, loved ones, the court system need to give them the help that they need.
Now, Woods tells me that she did speak with her son today, though she would not tell me exactly what they talked about. She says that needs to stay between a mother and son. Joyce.
I asked Darrell Brooks's mother, Dawn Woods, about how she felt about today's verdict. Her son found guilty on all counts.
Do I think it's fair? No. You know, I don't know why they couldn't go into concurrent sessions instead of just, he would not live 6 life sentences.
What do you think he should have gotten?
I don't know what they just say he deliberately killed those people. He did not deliberately kill those people. It hurts more than anything.
What do you think he's thinking? Have you talked to him?
I did, but I won't share.
Okay. Did you talk to him yesterday?
No, he called me today after he got out of court. We talked briefly.
We also discussed how she plans to move forward now that she'll only see her son behind bars.
Hopefully, this will bring awareness to mental illness via our senators and our governors and elected officials, court, police. Very little help is done for individuals who are incarcerated with mental illness.
How do you feel right now?
Right now, I just want to curl up and die.
No, not one tear, Lenny.
That's how I feel right now. I just want to go somewhere. Just curl up.
She knew he was dangerous, so she's just going to let him out.
My child is alive. I have to stay alive.
So why did she let him out? If she knew he was danger, if she knew he was mental, obviously, why did she let him out? It makes no dang sense, you guys. It makes no sense whatsoever. Because she knew that, I almost feel like it was dumb for her to do that, like for herself, because I think she was scared of him. He ran all over her too. Thank you, John Anna. Oh, yeah, I think the chat's just I don't know who's being pissy tonight. I'm not sure where it's coming from, and I'm not pointing fingers at any one person, but I'm just saying if y'all are gonna talk back and forth to each other, just make sure it comes out right. Because sometimes when you type it in the chat, it doesn't sound the same way as when you type it. If you know what I mean. If you know what I mean. If you don't give a damn, then Crazy Casey's just gonna boot you. And that's all there is to it. All right, we're not done yet. Wait, I want to hear this one more time. Listen, y'all. Listen to this.
The court will call State of Wisconsin versus Darrell Brooks, case number 21 CF 1848. May I have the appearances, please?
Good afternoon, Judge Sue Opper, Leslie Basie, and Zach Wichow, appearing for the state of Wisconsin.
Good morning, Your Honor. My name is Darrell Brooks, Jr. My name is Darrell Brooks, Jr. Say my name. Darrell Brooks, Jr. I'm in the say my name. Darrell Brooks, Jr. It is by special appearance. No grounds. Okay. Did you speak to the complainant of the domestic allegations at that time?
Objection. The use of the word complainant.
Sustained as to the form of the question.
That question wasn't answered, but okay.
That dang Sealand. If Sealands could talk.
So there'd been the subpoena sheet that would have had your name and a number of different.
What do you mean my name? What are you referring to?
I believe it would have said Darrell Brooks on it.
Are you aware that I don't identify by that name?
Objection, argument.
Sustained.
Sorry.
What do you mean by complaint?
The complaint would be a reference to the charges in this matter. So is that what your subpoena said? Was that the language of your subpoena? The logistics?
We've been down this road under 90611, Mr. Brooks. I need you to ask a relevant question to this witness.
That was relevant. He said what was on his
No,
subpoena.
you've talked at length about the subpoena. So under 90611, move on to a new topic, please.
Also believes that you could always use communication when you need to delay.
I know you're holding up your objection sign, sir, but I am giving you the opportunity to come back over here. Would you like to come back to this courtroom? Record should reflect he's holding up his objection sign. It appears that he's writing I don't know what, of course. Mr. Brooks, I'm going to ask you again. Would you like to come back to this courtroom for opening statements?
So I'm on the record.
You are. If you would please address my question.
So you want me to come back over there just to get brought back over here?
That's not what I asked you, sir. I told you, I advised you I would like you back here. It's always my preference that you're here. You demonstrated previously that you can follow some rules. When the jury is present, the jury's going to be brought back in shortly for opening statements. The state will go first as they bear the burden of proof, and then you will be given an opportunity to also present an opening statement. So my question to you is, do you want to come back to this courtroom, sir?
So I can get sent back over here, because as soon as I say something, I'm going to get sent out.
If you follow the rules of decorum and courtesy and civility, you will remain. But if you choose to not do that, then you run the risk of once again forfeiting your right to be present.
You say that even though I never consented to being taken out. You say that everything is about the decorum and all this. That's what you say. But when I'm raising issues of understanding, which I keep telling you I don't understand, then it's looked at as being disruptive. It's looked at as intentionally trying to be disruptive. And I don't understand why everything I say has to have some type of disruption title to it. It's even been put on record numerous times with inaccuracy. Even what happened today, nobody reported on record about me being bruised up and having to get bandaged up and all these things, but it was put on me, laid at my feet, as if me, quote unquote, being disruptive was deserving of what happened to me. I'm simply trying to have a fair trial. And if I don't, forgive me for being this way, Your Honor, but if I don't understand, I'm going to ask questions. That's the only way I can have clarity, is by asking questions. And you have refused to answer anything, but I have to answer everything you ask me. Where's the give and take? It should be fair. I'm not asking for legal advice. I'm not asking for nothing like that. I'm asking to simply have clarification so that I can understand. I cannot put on an adequate defense if I don't understand something. Do you see these boxes I got right here? Do you think I was able to go through everything in those boxes?
Mr. Brooks, I'm not going to go through this with you again where you attempt to put on the record all of these issues that you have when we're in the middle of a trial. All right? You willingly waived your right to an attorney. I made all of those findings, so we will go forward.
You made those findings.
I am not obligated to answer questions.
You made
when
those
you ask me
filings.
questions, I'm going to mute him.
Yeah.
I am not obligated to answer questions that explain procedure or the law. I am obligated to address motions to address that are based in law and fact. I'm obligated to address objections, for example, whether it be to testimony or evidence or questions posed to witnesses. But I am not obligated, sir, to provide you with an explanation of the law, of the procedure. And with that, since I gave him two opportunities to answer a very direct question, and that was, do you want to come back to this courtroom? And he chose not to answer it, but instead ask a question and then start making statements about his lack of understanding. I will find that his non-response, that he has not answered directly, which is willing to follow the rules of decorum and courtesy and civility, and without such a pledge, he will remain in that courtroom. He's muted. The record should reflect. It appears he's talking as well. He's making hand gestures. His lips are moving behind the mask. And I just wanted to make a record of that. All right, then we will have the jurors brought in, and then the state can then proceed with its opening statement.
We see these boxes right here. This box alone is 45 or 50 pounds full of so much information. I haven't even gone through half of it. It was stated for the record that the discovery, in its entirety, was brung to my housing unit on the 29th of September, which trial was scheduled, that would be a Thursday, which trial was scheduled for Monday. How can I possibly go through all that, all the paperwork, all the digital discovery and things of that nature? How can I go through all of that and be prepared in 3 days?
I must also advise you that I can make no guarantees about your access to legal materials while in the jail. Did you hear me advise you of that?
Yes, I did.
That's a clear bias. I did not have time to prepare for this. Everything I'm doing is off the top of my head, winging it, taking it as it comes, when the court is well aware that I was not prepared.
I was further advising you, sir, that this trial will start next Monday, October 3rd.
I raised the issue that it should be an adjournment at least At the minimum, it should be an adjournment because of that fact. At least to let me go through all the discovery. That was denied. No valid reason was stated for that when Your Honor knew there is no possible way, humanly possible, that I could be ready for a trial of this magnitude in 3 days.
So here's the important takeaway, in my humble opinion, sir. You are being advised that I am not going to adjourn the trial that is scheduled to start next week. Did you hear me say that?
I heard you say that. And as we sit here today, I'm still not even understanding the nature and cause of the charges. That hasn't even been proven.
Are you further informed that all of this conduct primarily relates to what has been referred to as the Waukesha Parade incident?
They word it as a different way. They call it an attack.
I don't know who they is, and I don't frankly care.
If every valid argument that I raised is taken by the court as a sign of disrespect or a sign of trying to intentionally be disruptive or causing a problem, when I'm merely seeking understanding, because I don't understand. I'm merely seeking to understand why this information has yet to be provided and we're this far into this matter.
Advise, sir, that the judge, that's me, cannot be your attorney and cannot give you any legal advice. You are further advised that the district attorney cannot be your attorney and cannot give you legal advice.
Which brings me to the motion to subpoena witnesses. I did everything that was asked of me by the court pertaining to those subpoenas. It was understood by the court that this is my first time ever having to do this. I didn't understand how to properly fill out the subpoenas, at which the prosecution volunteered that they would give assistance. The only assistance I received was for them to check to see if it was filled out right. That was it. That doesn't amount to any assistance. I was still left to fill it out on my own, and then when I did that, corrections still had to be made, which would verify what I was saying. I don't know how to do this.
You are further advised that the judge, district attorney, and court personnel are not required to explain court procedures or the law. You are further advised that the judge cannot treat you any differently because you do not have an attorney. You are further advised that you will be required to follow all legal rules and procedures that an attorney would have to follow in court, and that it may be difficult for you to challenge evidence presented by the district attorney if your case goes to trial. You are further advised that it may be difficult for you to present evidence. You are further advised that if you want to testify, you must be sworn as a witness and answer questions from the district attorney. You are further advised that it may be difficult for you to do a good job as your own attorney. Did you hear the advisements that I just read to you, sir?
Yeah, I heard it. Obviously, the court knows that I'm not privileged to the same filing system. Which brings me to the reason why I brought up the issue of assistance of counsel. Under the Sixth Amendment, I have the right to assistance of counsel. It doesn't say anything about representing yourself without assistance of counsel. Having counsel represent you and having assistance of counsel is two totally different things.
Why did you not check this box?
Because it is my understanding that representing myself pro per, I can have standby counsel. So that, in a sense, is why that box specifically is not checked.
That is not a correct statement of the law, sir.
You, Your Honor, gave me paperwork that was a waiver of counsel. We both know that any contract can be altered if I don't agree to certain terms. I crossed out everything in that paperwork that I did not agree or consent to, and specifically wrote on that paperwork that I do not waive my right to assistance of counsel. At the very least, I should have been awarded a standby counsel.
Mr. Brooks, the case law makes clear you cannot act as your own attorney, right? Exercise your right of self-representation while simultaneously exercising the right to counsel. Did you hear me say that?
Yes, I heard you say that, but that wasn't what I was attempting to do.
Not someone to represent me, to speak for me, but someone to help me do things in a timely fashion. Get things filed in a timely fashion. Get motions together in a timely fashion. Make preparations to get things done that I don't have the privilege to do in my current situation of being housed at the Waukesha County.
Who peppers their rations? I have never peppered a ration ever. I've never ever peppered my ration.
Jail.
It is my understanding, sir, that based upon the motion that was filed, the waiver of attorney form that was filed, and the proceedings that have been held over the course of the last 2 days, you wish to represent yourself.
I wish to represent myself pro per, but I do not wish that my entire Sixth Amendment right not be honored. I essentially would only be agreeing to the part where I want to represent myself. Just that stipulation of my Sixth Amendment and no other stipulation of my Sixth Amendment.
Your Sixth Amendment right to counsel is pretty straightforward, sir. You have the right to an attorney. You have the right to represent yourself. Those two things don't always go hand in hand. In fact, never go hand in hand.
But yet, I'm still forced to come in here with zero help.
You will have the sole responsibility to cross-examine witnesses, to present evidence, to make arguments to the court, etc. Did you hear me say that?
Yes, ma'am.
And you're informed of all of that?
I am informed.
Any questions regarding that?
Not at all.
I think it's clear that prejudiced my defense. Knowing that the prosecution has everything that they need for this matter at their fingertips. And I have to jump through every hoop possible to even get things filed in a timely fashion. It was stated for the record that the unit that I'm housed in the Waukesha County Jail, and per Jail Administrator Angela Wallenhoff, that I'm only allowed out of my cell for a few hours a day. So I'm roughly locked down 22 hours a day. Not given the privilege to access everything that I should be able to at the time that I should be if I was general population. Arrangements could have been made months ago for me to be at least in some form general population with an upcoming trial. Reference was made to being able to use LexisNexis or whatever it's called. We call it the law library. That may be the easier way to describe it. I'm only allowed to access the law library at certain times during the day. The rule of the jail is that when you're not in the day room, you can't access the law library, which is on tablets. We are not allowed to have those tablets in our cells. That prejudiced my defense. How can I work on my case? How can I look up certain case laws? How can I do any of this if I don't have full access to it? I even suggested some type of order that could be made by the court to allow me more time out of my cell, or to talk to jail administration about allowing me more time out of my cell to be able to use those when needed. And to be frank, in a proceeding of this magnitude, there should not be even a time where where I don't have access to the materials that I need.
Don't be blaming Frank.
If I'm not in the courtroom or sleeping, I should be awarded the time to work on this case, seeing as how I only had a couple days to prepare for a trial of this magnitude.
I'm the jail administrator for the Waukesha County Sheriff's Department. I am head of the division in charge of all staff and inmate issues.
Although Mr. Brooks is under a COVID protocol, is he still allowed to review his discovery materials in his jail cell?
Yes.
To your knowledge, are those materials?
The objection is overruled.
I'm sorry. To your knowledge, if you know, are his discovery materials currently in his jail cell?
Yes, ma'am, to the best of my knowledge.
Okay.
Is
he still
able? To that, Your Honor. I'm not allowed
Sir,
to
her
keep.
answer stands. There's no question to which to
I
object.
object to that. There is.
You can't testify at the moment. If you want to provide further information after she is done testifying, I will give you that opportunity. Your objection is overruled.
Will she be able to stay right there so I can ask the question?
It's not your time yet. You have to wait. So this is the final warning. Okay, I've given you a lot of leeway today.
You have not, Your Honor. You haven't. No.
I am turning to Attorney Opper. It is her opportunity, her turn to ask this witness a question.
And it is my right to be able to object, just like she objected when I was asked.
Right. When the court rules on an objection, usually the party who objects stays silent. I rule on the objection.
Usually.
The parties don't debate the ruling. It's noted for appeal. And then we move on.
Then I would like to put you on notice that I will be appealing that judicial decision that you are making.
Next question, Attorney Opper.
The judicial determination.
Ms. Molenhop, while on COVID protocol, does Mr. Brooks have access to the tablets in his jail cell?
Yes, ma'am.
And that tablet has legal materials available for him to access if he so chooses. Is that correct?
Yes, ma'am.
And while he is on COVID protocol, does he have access to the conference room, which also contains a computer with further legal materials?
Yes, ma'am.
And thank you. So, Ms. Wolenhop, I was asking you about the digital discovery materials. You testified that you're aware there is a thumb drive available for Mr. Brooks' use that is maintained in his pod, and all he has to do is ask for it, correct?
Correct, ma'am.
And that in order for him to view the contents of the thumb drive, he'd have to use the computer in the conference room, correct?
Correct, ma'am.
And that is available to Mr. Brooks upon his request, correct?
Correct, ma'am.
And nothing about this protocol then would limit his access to any of his discovery materials, correct, ma'am?
Objection.
Overruled. She may answer.
Correct, ma'am.
And he would have access to the telephone if he wants it.
Objection.
Overruled. She may answer.
Yes, ma'am.
And there would be nothing that would restrict his ability to come to court each day?
Objection.
Overruled.
Correct, ma'am.
And when he comes to court each day, he has the ability to bring whatever discovery materials with him that he wants. Is that correct?
Objection.
Overruled.
Correct, ma'am.
And in fact, there's a card available for him to do that if he so requests.
Objection.
Overruled.
That is correct, ma'am. Correctional officers would transport it, but yes, there's a card available.
Sure.
And you stated that you read the report after you submitted it. Do you know how long it was before you were able to see the report that you typed?
Objection relevance.
Grounds.
Sustained.
Well, he already answered that.
Then I'll object as asked and answered, Your Honor.
Sustained.
That question wasn't answered, but okay. Do you recall when you typed your report?
Objection relevance.
Grounds.
Sustained. Not relevant.
How's that not relevant
if he already answered that he typed the report?
Please continue, sir.
Mind-boggling.
Grounds for the sustain.
Relevance.
He answered that he typed the report. So how's it not relevant if he recalls when he typed it? From your testimony, it seems like you've been doing crash reconstructions from quite some time. Is that fair to say?
Yes, sir.
You said normally you don't put the speed calculation in the diagram. Would it be any reason for that?
It's in the report. It's not necessary to put it in the diagram.
Have you ever done that before?
Could you rephrase the question?
Have you ever not included the speed analysis in any crash reconstructions that you've done before this one?
Are you referring to the diagram or are you referring to the report?
Referring to the diagrams.
No, I don't. I do not put speed calculation results in diagrams.
On any of them?
On any of them.
Did you create any diagram with the speed calculations present on it?
No, I don't. The diagram that I created is the one that was up on the screen.
And then from there you put the speed calculations just in the report?
Yeah, I normally just put them in the report, yes. I don't have any recollection of putting one in the diagram.
Would it be fair to say that it may be a little bit difficult to locate what you analyze for speed if it's not in the diagram?
No.
So if you wanted to know the calculation of the speed, you would have to read the report.
Correct.
Would it be fair to say that it might be easier to find if it was included in the diagram?
My diagram is included with my report, and that's all one unit, so it is in the report.
You made reference to something called Newton's Law. Can you explain a little bit further what that is?
Newton's laws of motion are what we use as a big step in our reconstruction field. A lot of formulas are derived from Newton's laws, including the formula that we use to calculate the vehicle's average speed. Sir Isaac Newton obviously invented the laws of motion. We all learned that in high school, and that's part of the process that came to the formula that I use to calculate the average speed.
I always thought of Newton as gravity, so that was a bit of new information.
That's one of my favorites. Thank you for watching, everyone. And hey, don't forget to hit that like button and that subscribe button so you'll be notified the next time we upload a video. Have a blessed weekend and stay safe.